All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. Record should reflect that the state appears this morning by District Attorney Sue Opper, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Wichow, and the defendant Daryl Brooks appears in person in custody. I'd also like the record to reflect that he is appearing in jail attire today. He's also wearing a mask.
I object to that, Your Honor. I do not identify by that name and would like the opportunity to state that I'm here concerning this matter as third-party intervener in this matter, appearing as authorized representative for my client. I accept for value in return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and would like to now reserve my rights, if I may.
Mr. Brooks, you just interrupted me within a minute of us starting this case here today. I'm asking you to respectfully not interrupt me. That's the second time, so I can go through the list of things that I need to get through this morning.
I just wanted it stated for the record that
Mr. Brooks,
it
wasn't the proper time to do that. That's now the third interruption. So,
with all due respect, Your Honor,
Mr. Brooks, by saying all due respect doesn't change the fact that you're interrupting me. Your objection is noted, all right? But you need to stop interrupting me so I can get through what needs to be done.
But it is my
I have
right
a number
to-
of documents that I need to discuss this morning.
It is my right to,
Mr. Brooks, you do not have a right to interrupt the court.
No,
I will
that
remind
was
you
not
once
my
again
intention.
of the Supreme Court rule. It's on a yellow laminated, double-sided piece of paper that is before you. I
did not
checked, I
recognize
verified,
that.
it is.
I accept it in return for
Mr.
value,
Brooks, that's
Your
yet
Honor.
another interruption. Let me get through this, please.
I just want, for the
You will
record,
have an opportunity when I
I'll-
give you an
I want
opportunity. No
to
one
state
else
it-
is speaking at the moment but me. You need to stop interrupting.
I don't identify by that name.
Mr. Brooks, I am going to keep going. You are warned. You need to follow the standards of courtesy and decorum for the courts of Wisconsin. Chapter 62, that's another interruption.
I intend to follow decorum.
This court comes with a history of Mr. Brooks interrupting now. This is day 4, and every day Mr. Brooks has interrupted. It has resulted in Mr. Brooks being placed in a neighboring courtroom so that this court can efficiently, effectively, and with dignity preside over this case here today. I am well aware that's another interruption. I'm well aware. Stop
respectfully,
talking.
which I have the right to do.
I'm well aware,
And
Mr. Brooks,
I
that
have
you
not
object to the
intended to
name that
cause any,
has
disruption.
identified on the information and all documents in
wanted
this
noted
case.
for the record
Your
that I
objection
do
is
not
noted. It
identify
does
by
not
that
need to be
name.
repeated. I will make a record right now. The
May I
court
have the
notes
opportunity to
a
preserve my
continuing
rights, Your
objection
Honor?
by Mr. Brooks of his name and that he objects to being here. I know he's filed a number of documents previously
I never
related
objected
to
to
that.
being
Those
here. I just
documents
state-
are
I tried
of
to
record.
state
There's
that
another
for the record,
document
Your
that's
Honor.
filed. At least 2 more interruptions. Just now, I believe I'm up to 8. Mr. Brooks, you're advised that continued interruptions will result in you forfeiting your right to be present in this courtroom, where you'll be taken to the courtroom next door to appear by video and audio
I don't
means to
consent
participate.
being removed from the courtroom, Your Honor.
That's another
And
interruption.
you haven't shown me any lawful case law that I can be removed from the court
Mr. Brooks?
proceedings in a trial and forced under coercion and duress to appear in the trial that I am needed, that I've tried to express that I have the right to
Mr.
be
Brooks, there's a
present for.
proper manner in which you raise objections. You have not followed that proper procedure. You are unable or unwilling to abide by simple rules of civility.
You haven't
You
given me the
interrupt,
chance to
you don't wait for
state my
anyone
name.
to finish, and it will result with you being removed from the courtroom.
I
So
respectfully
you are
object to
once
that, Your
again reminded of that. I'm going to give a little slack at the moment only because we are not in the presence of the jury. I'd like to go through a couple of things, the first of which is the jail Attire, Mr. Brooks, we, meaning myself and the jail, have made arrangements by allowing folks to bring in street clothing for you. You've appeared previously in a suit and tie, very appropriate for a trial. If you no longer have those clothes available, the jail has a supply of clothes that they can also lend to an inmate. The reason we make those arrangements during trial, sir, is because this court has taken a number of steps to shield from this jury that you are in custody. Your hands are not shackled. Okay, there are skirts around each one of the tables. I'm aware of the feet shackles. That's yet another interruption. I'm aware of the shackles on your feet, and that's why the skirts are on your table and frankly all of the tables, right? So that it appears to be the same for anyone coming in and viewing. Again, arrangements have been made for you to appear in street clothes or civilian clothes. I would like you to appear in street clothes, and the reason why, sir, is to reduce or even eliminate even the appearance that you are in custody. And it is your choice, though. Are you willing to go back to your cell and put on your suit?
It is my right to do so or to not do so. And at this point, Your Honor, who doesn't know that I'm in custody?
Mr. Brooks, I've had many trials with individuals who were in custody, and when I've talked to the jurors after the conclusion of the case, they had no idea. The whole point of allowing for street clothing is not only to shield jurors from the fact that you are in custody, but also you being in a suit and a tie or other street clothing, I think also lends to the dignity of the proceedings. This is a trial. Again, it is your choice. Are you willing to go back to your cell and be dressed in the street clothes that you previously appeared in?
With all due respect, I do not agree with that assessment whatsoever. There's no possible way that anybody will not know that I am in custody. I think that's a well-known fact because it's reported on every day in the media. It's shown every day on the news where I am, what jail I'm housed in, and that I'm in custody. It's virtually impossible for anybody to not know that I'm in custody.
Mr. Brooks, did you hear the question that I asked you?
And I respectfully keep the position that I just put on the record.
Mr. Brooks, I will ask you again. Are you willing to go back to your cell or into the jail and put on street clothes?
I do not consent or agree to anything that you just stated, Your Honor.
All right, he did not provide an answer to a very direct question. Let the record be very clear that Mr. Brooks was given multiple opportunities to answer that question. And go back, Mr. Brooks, that's yet another interruption. I will advise you, sir, that at any point in time, if you wish to put street clothes on, I would give you that opportunity to do so. You've already heard it is my preference. You've already heard me advise you regarding the steps that have been taken to shield the fact that you are in custody from the jurors. You refuse to answer my question about whether you would go back to the jail. That's another interruption. So based on his refusal and his choice to come, that's another interruption. Based upon his failure to answer my question directly, I will take that as a non-response, but he came to court here today. That's another interruption. I will take that because he's come to court here today in his jail attire, that is a choice that he has made freely, voluntarily and intelligently. No one has forced him to come to jail in those clothes. This court is encouraging him not to. He's appeared previously in his street clothes in what I would describe as a very nice suit and tie, but it is his choice to not do that, and we will proceed accordingly.
So while we're on the record, may I challenge the subject matter jurisdiction?
No, you may not, sir. You need to file a motion in order to do that.
So
Mr.
the
Brooks?
motions I filed haven't even been responded to. I gave
Mr. Brooks, you're
3-day
interrupting me
No,
yet
you
again.
just weren't speaking,
All right,
so I didn't
Mr.
interrupt.
Brooks, you are now going to be removed to the
I
other
don't
courtroom.
consent to that.
I have
I
had
am under
a
duress
dozen or
by having
more interruptions.
I
We'll
have
be
shock-
off the record while we
shocks
do
on my
that.
ankle.
Thank you,
I don't
everyone.
agree to a stop. I move for a motion to dismiss for being under duress and being coerced into a contract that I did not consent or agree to. I do not. I have a right to be present for trial.
And right now, all audio, oh, he can't even. Yes. Are you're able to see the screen, is that right? Okay.
Yes.
I'll publish that as well. All right, we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks. On every day that we have been in court since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case. I should also make a record at the moment he is muted because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom, that he was resisting, that at one point he took off a shoe and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing in one ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly so that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system. Today is a little bit different in that there is no Zoom. And so, but this court, with the blessing of technology in this new building, have the ability to call in one room system to the other. That is why we're able to see and, when appropriately, hear him when unmuted. And then there are the 4 camera angles that are presently from this courtroom. I have the camera in the other courtroom on a single camera since he's the only individual in there. This court has, in essence, extended this courtroom to the neighboring courtroom. While there is ample evidence in the record, not only through the proceedings up to this point, but this morning alone, that through his conduct, he has forfeited his right to be present. I'd also make a finding that he is appearing from that courtroom, and that because of the audio and visual equipment and system that we have in place, that it is the functional equivalent of being present in this courtroom. This court has relied repeatedly on Illinois versus Allen. I've read portions of that case into the record. I don't intend to go through that at length here today, other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has become and has demonstrated over the course of these last few days. One option is to bind and gag him. I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt. I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly. Mr. Brooks today, of course, showed up in court from the jail in his jail attire. He does that by his choice. I gave him the opportunity to go back to the jail to put on his suit and tie or other street clothes. He refused to answer that question. This court will continue with this trial, as I have previously indicated. There are many resources that have been put into bringing this day to bear, and it is important for all involved that this trial continue. Again, Mr. Brooks is given the opportunity to appear from that other courtroom. At this point, I'm still in the final housekeeping matters, and so he clearly has forfeited his right to be present for that. I will advise Mr. Brooks, as I have advised him repeatedly, if at any point in time he wants to come back and he is willing to promise that he will abide by the rules of courtesy and decorum and be civil and show respect for the court proceedings for all individuals in this courtroom, including Mr. Brooks himself, then he may come back in. It's also my intention to give him that opportunity at each new stage. But again, we are in the preliminary stage prior to the jury being brought in. I would note it's a little after 9:06 a.m. At all times throughout the court's statements thus far, since going back on the record, Mr. Brooks still appears to be communicating, or at least attempting to communicate with someone else. I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head no. At a point in time where it's clear he's disagreeing with something that I've said, I believe he can adequately hear, and that his statement earlier in the proceedings that he's hard of hearing is simply another tactic of his to disrupt, to delay, to create chaos. I will further advise Mr. Brooks that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those things at his peril. But I will, of course, take appropriate steps to limit what the jury can hear, if appropriate. All right, I've received a note, we need to reset the Polycom system, so I'm not sure what that means. I'll find out, and if appropriate, make a record as to why and whether that impacted anything that was happening in the other room. But at this point, while I'm not going to get off the bench, we're going to take a short recess for that resetting to take place.
I would request an opportunity to be heard then, Your Honor, when we go back on the record, please.
Absolutely. Polycom system has been reset. The information I received was that all of a sudden the audio was only going through 2 speakers and not all of them. A simple reboot of the Polycom system over there took care of that, and I've confirmed that it's working properly. Before I turn to you, Attorney Opper, because I'm not sure if Mr. Brooks heard this or not, at the very end, before I removed him, I wanted to make sure that the record is very clear. I will note a continuing objection to the issues he raises regarding his name and other things. There are filings that substantiate that. It will be my position it's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Daryl Brooks to proceed to trial. The court is well aware that the district attorney has an obligation and a duty to raise any concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant to proceed, can request an evaluation that's pursuant to 971.14 of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern, and I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him up until last week on this case, and you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his waiver of right to an attorney and his absolute desire that he expressed multiple times to represent himself. I would also add to he is coherent, he is intelligent, he knows the issues in the courtroom, he discusses what happened in court that day with these individuals he's speaking to. I am thoroughly convinced, Your Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written. His handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate. He drafted this himself in his jail cell last night, I presume. Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated, and the court has seen this since August 25th or so, as the motions were decided by the court, most of them to his detriment. His behavior became more and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had a situation where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. And I want to make that record. I tell this court as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record as to the need to proceed with this trial. We concur 100%. We would also note it's not just a matter of resources. It's the need to proceed to justice. It's the need to get justice for the crime victims who have patiently attended every one of these hearings. They have a constitutional right to trial. They have a constitutional right to a speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
Thank you, Attorney Opper, and I do appreciate you raising that with the court because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously, I personally haven't listened to the jail phone calls that you referenced, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit so that that can be part of the record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the examiners met face-to-face in the jail or in an appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done, as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is, I believe this trial needs to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding We are at the stage where we are at with Mr. Brooks muted in another courtroom because of his defiant actions. No one else. And I appreciate everyone's patience as the court goes through these things, frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction as he was advised to do yesterday. If he wanted me to consider something, I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it with to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence. And so I wanted to make that record. I don't have anything from him this morning regarding any additional jury instructions. Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have.
Any objection to those?
No.
All right. Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based upon that yes or no. The microphone is unmuted. Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time? Yeah, but you know what? Your volume's a little low, so we're gonna have them adjusted over there and in here. So give us a second. Where is the microphone? It looks like it's in front of the monitor. Mr. Brooks? Try again.
Am I on the record?
You are on the record. Oop, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday? Go ahead, answer please. All right, your objection is noted for the record, and I'm just putting the mute back on. He provided that objection without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you. Hold on, the volume is not being appropriate at the moment. There needs. Try it again, sir. I apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer, so I just want to make that record. I'm going to go take a recess. I'll just mute while we're doing that, just so I can figure out what the audio issue is, and then we'll go from there. appear to have our technical issue resolved. That issue solely concerned the audio from the microphones in front of Mr. Brooks and the two room systems cooperating, and we were having difficulty in this courtroom hearing Mr. Brooks. I believe that issue has now been resolved. When I needed to take the break for the audio issue, I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting a small cut to a finger as a result of when he was removed from this courtroom and taken to the other courtroom. I was further advised that there are no signs of blood, and that when asked, he refused to show his hands. At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done. And I also want to make a record that Mr. Brooks has put his shirt back on. He continues to sit with his back to the camera. Mr. Brooks, I want you to be advised that I believe it's important that you face the camera so that you are facing the court. You can see and hear. It's my understanding you were not willing to cooperate with being shackled, and for the moment you are not. But at this point, given your conduct from before, I'm going to require, after we take the next break, that the Sheriff's Department put you in the chair face forward and with shackles on your ankle as you are in custody, and that is appropriate. Now, I want to turn back to the issue with the jury instructions, Mr. Brooks. You indicated you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir. You need to turn around so I can hear you. Part of the issue is he's also not facing the microphone, and so I need to hear him, and he needs to turn around. Mr. Brooks, I'll ask you once again, what is the legal basis for your objection to the jury instructions? I'll ask a third and final time, sir, what is the legal basis for your objection to the jury instructions?
I wasn't allowed to make, I can't even hear what she's saying all the way, man. It's too low.
You want your headset?
Mr. Brooks, I can hear the deputies over there. I know they can hear me. That's been confirmed. There is the headset available to use should you wish to use it. If you can't hear, I would ask that you put them on.
Mr. Brooks? You can just put it down.
I'm able to hear. He said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer the question, what is the legal basis for the objection? I asked that question 3 times based upon that non-response. His objection is noted for the record, and I will approve the preliminary jury instructions that are on file with the court. Obviously, they'll be uploaded once I read them, but all parties have been given copies of those. Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30 if Mr. Brooks had any paperwork and to ask him if he had any filings. He then provided this piece of paper and it was photocopied. Actually, it was date stamped, then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity to review this document. based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling. I don't think there's anything the court needs to do with this document at this time.
All right, thank you. Then we'll move on to the motion for reconsideration. And again, I'm keeping Mr. Brooks muted so that I can get through this process orderly, efficiently. When necessary, I will unmute him if the court has questions. All right, Attorney Opper, I have read through the motion. Is there anything you want to add to what you have put in your filing?
Only one other observation, Your Honor, that since I filed that, the events of the last couple days, I think further support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify, and so not having their faces displayed, I think, would help ease some of that tension for those individuals.
Mr. Brooks, my first question to you is, do you have a position on the state's request in their motion for reconsideration? I'm looking for a yes or no answer. I'll unmute and provide that to me. Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
Sir, it's a written document that was filed, and you were provided a copy of that yesterday. We took a recess yesterday so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any position on their request for this court to reconsider the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces, while they testify?
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct, but they filed a motion for reconsideration. That's the document that was provided to you yesterday. I'm asking if you have any position on the request that I reconsider my ruling.
Yeah, it was everything's supposed to be public. This is a public trial. I don't understand why there would be even the need to reconsider what you already ruled on at this point, as far as to that particular issue.
I take your...
It's a public trial. It's a public trial. Anybody can essentially watch the trial. And like I said, as far as with the technology that we're in now, if they have to be sworn in by name, that in itself makes them easy to, if somebody wanted to pull them up or find them or find out who was testifying at any given time testimony is given, it'd be pretty easy for them to be found and to be seen. So, I mean, that's just the age we're in anyway, as far as with social media and Google and all these different things. We got all this technology basically at our fingertips. So I don't understand how it needs to be changed at this point when it was already ruled that this is a public trial. There's going to be a lot of things that are going to be shown. Why not keep everything public the way that it's intended to be? And because of the fact that you've already ruled on it, made that on a record,
Let's keep it the way it is.
All right, thank you, Mr. Brooks. I appreciate your legal analysis of that and your factual analysis of the prior ruling that this court gave. I thought you did an excellent job making some very good points, many of which I relied upon previously. There is a mechanism in the law for a party to bring a motion for reconsideration. Essentially, it requires that the party bringing the motion provide some new information or rely on an argument that the court aired as a matter of law in its prior ruling. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case. The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's Estes versus State of Texas. It's 381 U.S. 532, but I would note it's from 1965. In 1965, I would say even in the 1980s here in Waukesha County, there was really a presumption that cameras not be allowed in courtrooms at all. We have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I am certainly mindful of the potential stress that it may cause for victims and other witnesses to come into court and testify and to have their images broadcast as this trial is broadcast, not just locally, but nationally, and frankly, anywhere in the world anyone with a computer would want to watch. I would note, though, that prior to the point in time when this case came to trial, this court took significant efforts to keep victims' names private. There's a victim key that is on file. This court signed an order and even required Mr. Brooks to not disclose that information. That was one of the conditions set when bond was initially set. Now, that was by a court commissioner, of course, but that's still a ruling that this court adopts. In addition, I believe I've done, up to this point, everything that I could to preserve their privacy. I don't, frankly, want to create an issue that could be an appellate issue. I think this potentially could be that if I limit the capturing of victim and witnesses' images. I am aware of Marcy's Law. Certainly aware of the provisions that the state cites, but the fact remains the time has now come for this trial to be conducted. This is a public trial. The right to a public trial is not only for the defendant, but the state, but the public. All of the names are a matter of public record. This court obviously went through all of the names of the witnesses during the jury selection process. In the jury instruction, the names of all the victims will be read. The state agreed that it was time to put that information in a public document and on the record because the time for trial has come. The cameras in the courtroom not only facilitate the viewing of a public trial where anyone could walk in to this courtroom, space permitted, to watch, but it facilitates victim rights as well. And that is because there are a large number of victims in this case. This court could not have all the victims and the public and the media who wanted to be here present. Frankly, I think it's because of how this court has allowed the proceedings to be live streamed that we don't have even a full courtroom here today. There is no doubt this case has received great public interest. But this is a case that the state brought charges, and rightly so. I understand it won't be easy, it may be messy, it may even be stressful, but it's important to the integrity of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses, that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. They are in a special category as minors, and they, of course, if and when a juvenile witness testifies, may only be captured from the shoulders down. Their faces are not to be broadcast. Again, I am not unmindful of the impact, but in my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I would add to the record some of the points Mr. Brooks made. Not only are these names all a matter of public record, the technology that we have at our fingertips, there's Google, there's social media. It's very easily to identify these individuals and search for them in other ways. I'd also add that there have been a number of news reports, media accounts, newspaper articles about victims, naming them. I'm aware of one such broadcast this morning on Channel 4. I cannot presume that all victims, all witnesses want this. And I want to keep this trial going, and that's what we will do. So the request is denied. All right, I believe, let me just get back to my first note that I had for this morning, that we've covered all of the outstanding issues.
Your Honor, if I may, I don't want to interrupt, but I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
I'll tell you what I ruled previously. I've reviewed the filing. It's entitled Objection by Affidavit to the state's response and the court's opinion and order and defendant's disclosure statement by affidavit. It's an affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record. It has been accepted, it has been filed, and that your objection is noted. The court need not take any specific action as it relates to it. I further indicated that, again, no relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Can I say one thing about that?
Quickly, sir. I need to keep going.
I was filing that paperwork, I would say pursuant to the federal rules of criminal procedure under Rule 12.4 about the disclosure statement.
All right, I'll note
so
that for the record, sir, but it was not in your filing.
So that's a judicial determination, Your Honor?
I believe I had one other thing. Oh, I did want to put on the record, and that is when we were testing the audio, I did advise the Sheriff's Department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks?
The reason,
Mr. Brooks?
I would just want to.
Hold on, I'm gonna mute you for a second unless you stop and listen to me.
I just heard what you said, but I just.
I'm not asking for a response, sir. Mr. Brooks?
It's not.
Okay, you're interrupting, hold on. You're interrupting me, sir. I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm. I was told that the nurse would be coming in to see me, and then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court, because I feel like this needs to be addressed.
All right, Mr. Brooks, I understand your request. I'm denying the request to take an adjournment, or I'm sorry, to take a break at this time.
No, I'm not asking for a break. I didn't ask for a break. I was just saying that at the time that there was the technical difficulty recess, before you even called that, Your Honor, I was told that a nurse was coming in at that time. But then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm going to mute you for the time being. I want you to be aware, sir, I was advised regarding the cut. The bruise is new information. I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So I don't think I've overlooked anything, Attorney Opper, but anything you had on your list?
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity to do. Mr. Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded the right to be present for every proceedings in this trial.
All right, I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing, that you are exercising your right to dress in the jail attire. All right, then with that, I am going to just take a short recess just to have the jurors brought in.
And I think Mr. Brooks needs his objection signed.
We'll make sure he has it.
Thank you.
Let me actually go back on the record for a second. Mr. Brooks, when the jury comes in, I am going to read through the preliminary jury instructions. Since those have been approved by the court, if you happen to raise your sign, I'll note it for the record, but I'm not going to ask you for any type of argument on that because we've already had that opportunity to do so. It will take me some time to read through the instructions. I don't know if that will take us to the lunch hour or not. The state should be potentially prepared to go through its opening. Mr. Brooks, if we do get to that point where the state is giving its opening and you have an objection, you need to write down the objection in addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down the basis for the objection and what you're objecting to, in addition to holding up your sign. That's the procedure that we will follow. All right, now we're on a short break until the jury comes in. Gentlemen of the jury, and everyone may be seated. I appreciate your patience as the court addressed some important legal matters with the parties this morning. I'm going to read through the preliminary instructions at this time. Please pay careful attention. Just as a reminder, they're not something you need to memorize. Ultimately, at the close of the case, a very similar set of instructions are provided to the jurors to take back to the jury room. Before this trial begins, there are certain instructions you should have to better understand your functions as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based only on the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. All people deserve fair treatment in our justice system, regardless of their race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. People make assumptions and form opinions from their own personal backgrounds and experiences. Generally, we are aware of these things, but you should consider the possibility that you have biases of which you may not be aware, which can affect how you evaluate information and make decisions. You must carefully evaluate the evidence and resist any urge to reach a verdict that is influenced by any bias for or against any party, witness, or attorney. Personal opinions, preferences, or biases have no place in the courtroom, where our goal is to treat all parties equally and to arrive at a just and proper verdict based on the evidence. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the parties. If you come in contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by other means. If anyone does so despite you telling them not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report it to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments. The court will provide you with the materials. In making notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced at trial. During the course of a trial, the parties may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that the defendant's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance are expected to conduct themselves appropriately and in a manner that avoids creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. At the moment, Mr. Brooks is appearing from another courtroom. This must not influence your verdict in any manner. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offenses before you may find the defendant guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence, which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of a party, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorensen with intent to kill that person and while using a dangerous weapon. Contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The second count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Leanna Owen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The third count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Tamara Durand with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jane Coolidge with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Hospel with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon, contrary to section 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each one of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of any count of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present with respect to that count. One, as to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's acts was a substantial factor in producing the death. Two, as to each count, the defendant acted with the intent to kill the victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or for even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional homicide, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count one, you should find the defendant guilty of first-degree intentional homicide as charged in count one. If you are not so satisfied, you must find the defendant not guilty as to count one. If you find the defendant guilty of count one, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count two, you should find the defendant guilty of first-degree intentional homicide as charged in count two. If you are not so satisfied, you must find the defendant not guilty as to count two. If you find the defendant guilty of count two, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count three, you should find the defendant guilty of first-degree intentional homicide as charged in count three. If you are not so satisfied, you must find the defendant not guilty as to count three. If you find the defendant guilty of count three, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count four, you should find the defendant guilty of first-degree intentional homicide as charged in count four. If you are not so satisfied, you must find the defendant not guilty as to count four. If you find the defendant guilty of count 4, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 5, you should find the defendant guilty of first-degree intentional homicide as charged in count 5. If you are not so satisfied, you must find the defendant not guilty as to count 5. If you find the defendant guilty of count 5, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 6, you should find the defendant guilty of first-degree intentional homicide as charged in count 6. If you are not so satisfied, you must find the defendant not guilty as to count 6. If you find the defendant guilty of count 6, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? The defendant is charged with 61 separate counts of first-degree recklessly endangering safety, use of a dangerous weapon. The 7th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Nicole White under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 8th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eleanor Anders under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 9th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Sasha Catalan Castillo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 10th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 11th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Justin Gullickson under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 12th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Harry Guilfoyle under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 13th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Aiden Loughran under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 14th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Theo Maza under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 15th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tyler Pudliner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 16th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Connor Tank under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 17th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eric Teagues under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 18th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adelia Maffioli under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 19th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelly Graybow under circumstances which show utter disregard for life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 20th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Josh Craner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 21st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Riley Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 22nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Caden Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 23rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tucker Sparks under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 24th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21, 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Isabella Bartelt under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 25th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yuritsa Becerra Montez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 26th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Samantha Colo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 27th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Madison Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 28th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mackenzie Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 29th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mitchell Lampine under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 30th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kathleen Peelmeyer under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 31st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Julia Shulekow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 32nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Olivia Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 33rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jennifer Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 34th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jesselyn Torres under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 35th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Alice Urel under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 36th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Charlotte Urel under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 37th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Vivian Urel under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 38th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Grayson Urel under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 39th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lola Hospital under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 40th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tamara Rosentreter under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 41st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Betty Strang under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 42nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maria Alvarez Dominguez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 43rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Georgia Romelia Perez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 44th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Elliot Hallmark under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 45th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Benjamin Hallmark under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 46th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Patrick Heppy under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 47th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lori Loken under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. For a moment, I just want everyone to stand. You have a seat when ready. What type? Okay. The 48th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Marisol Lopez Gutierrez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 49th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Attire Lopez Rebolar under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 50th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21, 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Juan Marquez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 51st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21, 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of David Marquez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 52nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of William Mitchell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 53rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jason Petchloff under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, section 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 54th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Margaret Pachulis under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 55th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yamilet Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 56th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Alin Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 57th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Ashley Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 58th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jose Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 59th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maria Perez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 60th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Camila Perez Gonzalez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 61st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Isaac Foglia under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 62nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Deborah Ramirez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 63rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Charles Green under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 64th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lily Green under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, 939.63 sub 1 sub B of the Wisconsin statutes. The 65th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Brindley Harris under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 66th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelsey Knapp under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 67th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Owen Ricciati under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charged beyond a reasonable doubt. First degree recklessly endangering safety, as defined in section 941.30 sub 1 of the Wisconsin statutes, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of any count of first degree recklessly endangering safety, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present with respect to that count. 1. As to each count, the defendant endangered the safety of another human being. 2. As to each count, the defendant endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss of impairment of the function of any bodily member or organ or other serious bodily injury. 3. As to each count, the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The information alleges not only that the defendant committed the crimes of first degree recklessly endangering safety, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree recklessly endangering safety, you must answer the following questions, yes or no. It's actually one question per count. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree recklessly endangering safety. While using a dangerous weapon. If you are not so satisfied, you must answer the question no. Let me just read that one more time. Before you may answer this question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree recklessly endangering safety. Tell you what, I'm gonna let you all stand while I figure out if there's a typo in my instructions because I want to make sure I read them correctly. So go ahead and stand while I do that. All right, go ahead and have a seat. Just so the record is clear, I'm just going to start over with the use of a dangerous weapon part of this instruction. The information alleges not only that the defendant committed the crimes of first-degree recklessly endangering safety, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree recklessly endangering safety, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? Before you may answer the question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first degree recklessly endangering safety while using a dangerous weapon. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 7, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 7. If you are not so satisfied, you must find the defendant not guilty as to count 7. If you find the defendant guilty of count 7, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 8, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 8. If you are not so satisfied, you must find the defendant not guilty as to count 8. If you find the defendant guilty of count 8, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 9, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 9. If you are not so satisfied, you must find the defendant not guilty as to count 9. If you find the defendant guilty of count 9, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 10, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 10. If you are not so satisfied, you must find the defendant not guilty as to count 10. If you find the defendant guilty of count 10, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 11, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 11. If you are not so satisfied, you must find that the defendant not guilty as to count 11. If you find the defendant guilty of count 11, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 12, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 12. If you are not so satisfied, you must find the defendant not guilty as to count 12. If you find the defendant guilty of count 12, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 13, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 13. If you are not so satisfied, you must find the defendant not guilty as to count 13. If you find the defendant guilty of count 13, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 14, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 14. If you are not so satisfied, you must find the defendant not guilty as to count 14. If you find the defendant guilty of count 14, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 15, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 15. If you are not so satisfied, you must find the defendant not guilty as to count 15. If you find the defendant guilty of count 15, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 16, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 16. If you are not so satisfied, you must find the defendant not guilty as to count 16. If you find the defendant guilty of count 16, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 17, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 17. If you are not so satisfied, you must find the defendant not guilty as to count 17. If you find the defendant guilty of count 17, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 18, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 18. If you are not so satisfied, you must find the defendant not guilty as to count 18. If you find the defendant guilty of count 18, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 19, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 19. If you are not so satisfied, you must find the defendant not guilty as to count 19. If you find the defendant guilty of count 19, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 20, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 20. If you are not so satisfied, you must find the defendant not guilty as to count 20. If you find the defendant guilty of count 20, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 21, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 21. If you are not so satisfied, you must find the defendant not guilty as to count 21. If you find the defendant guilty of count 21, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 22, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 22. If you are not so satisfied, you must find the defendant not guilty as to count 22. If you find the defendant guilty of count 22, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 23, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 23. If you are not so satisfied, you must find the defendant not guilty as to count 23. If you find the defendant guilty of count 23, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 24, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 24. If you are not so satisfied, you must find the defendant not guilty as to count 24. If you find the defendant guilty of count 24, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 25, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 25. If you are not so satisfied, you must find the defendant not guilty as to count 25. If you find the defendant guilty of count 25, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 26, you should find the defendant guilty of count 26. If you are not so satisfied, you must find the defendant not guilty as to count 26. If you find the defendant guilty of count 26, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 27, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 27. If you are not so satisfied, you must find the defendant not guilty as to count 27. If you find the defendant guilty of count 27, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 28, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 28. If you are not so satisfied, you must find the defendant not guilty as to count 28. If you find the defendant guilty of count 28, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 29, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 29. If you are not so satisfied, you must find the defendant not guilty as to count 29. If you find the defendant guilty of count 29, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 30, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 30. If you are not so satisfied, you must find the defendant not guilty as to count 30. If you find the defendant guilty of count 30, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 31, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 31. If you are not so satisfied, you must find the defendant not guilty as to count 31. If you find the defendant guilty of count 31, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 32, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 32. If you are not so satisfied, you must find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty as to count 32. If you find the defendant guilty of count 32, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 33, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 33. If you are not so satisfied, you must find the defendant not guilty as to count 33. If you find the defendant guilty of count 33, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 34, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 34. If you are not so satisfied, you must find the defendant not guilty as to count 34. If you find the defendant guilty of count 34, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 35, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 35. If you are not so satisfied, you must find the defendant not guilty as to count 35. If you find the defendant guilty of count 35, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 36, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 36. If you are not so satisfied, you must find the defendant not guilty as to count 36. If you find the defendant guilty of count 36, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 37, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 37. If you are not so satisfied, you must find the defendant not guilty as to count 37. If you find the defendant guilty of count 37, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? Ladies and gentlemen of the jury, I still have many pages of my jury instructions yet to read to you. However, it's 11:54, and I would like to break, at least for the jurors, to have lunch. I have some legal issues I do need to take up with the parties, but when you come back, the court will continue where we left off with the jury instructions. The jurors are excused for lunch. At least an hour for them. It might be more, I'm not sure. It depends on when we break. All right, thank you. Be seated. As I indicated prior to bringing the jury in, because of the process that was utilized for this court to approve of the jury instructions, and Mr. Brooks was provided with opportunities to object and provide input, I would not be taking a break or acknowledging, at least at that point on the record, any objection to those. Nonetheless, he held up his objection sign for much of the reading of the preliminary instructions. At 10:37 a.m., I received a note. I don't consent to that name. It is not me. It is not my name. Please let me object to this as it is my right. His objection is noted. I'm not going to take any further argument on that for the reasons I've already stated. At 10:48 a.m., he sent another note. Are you going to acknowledge my objection? What law are you citing when you cite intent? How do I know it's what the law actually says? I would once again refer Mr. Brooks to document number 244, the waiver of right to attorney form. This court is under no obligation and in fact cannot give him legal advice and is not required to explain court procedures or the law. He was provided with a couple of different copies of the jury instructions. There was an original set, and then there was the set with the modifications. All of the instruction numbers are left in the jury instructions. There was a discussion on the record yesterday about access to jury instructions, even though this court is under no obligation, and explained that to him during the colloquy regarding the waiver of counsel, that I could not make any assurances about access to legal materials. I note he has his objection sign up. His objection is noted, but at this point, I'm still reading through these objections. I don't plan on having the parties make any additional comments regarding the jury, the preliminary jury instructions. Again, we had ample opportunity for that discussion prior to the court's approval. Mr. Brooks, I will once again advise you that you are welcome back into this courtroom should you wish, if you are able to conform your conduct to the rules of courtesy and decorum that you have been previously been advised about. Once again, direct your attention to SCR Chapter 62, Standards of Courtesy and Decorum for the Courts of Wisconsin. Would also direct you to Illinois versus Allen. That's the case I've been relying upon for the procedures that have been employed. Mr. Brooks is holding up the objection sign. I don't have anything in writing, which is the procedure that I told him he needed to follow in terms of me addressing any objections. So if he wants to write down what his objection is, and we'll file that. We'll also indicate the time. If appropriate, I'll take that up after the break, but at this point I will be breaking for the noon hour, for the lunch hour. It's 12 noon. Let's be back here at 1 p.m.
And could he also have the opportunity to change into his street clothes if he wants during the lunch break?
Absolutely, during the lunch break, I'm told, will be seen by jail medical staff for the concerns that he's raised. He will be given the opportunity to change into his street clothing, should he choose. Of course, when he comes back, once again, invited back into this courtroom, should he choose.
Yes, and I would just observe for the record that for about the last hour while you were reading the jury instructions, Mr. Brooks did not appear to be in any physical pain or medical distress. He's been moving around freely, shuffling his papers, reading his documents, actually behaving quite appropriately, standing quietly, oftentimes with his hands folded, and at times listening to the court, and at times it appears he's working or looking at materials on his table.
All right, thank you. I appreciate that. We are in recess.
Thank you.
All right, thank you, everyone. I wanted to put we're back on the record. I wanted to put one other thing on the record. Based upon the attendance at the trial thus far, and given the number of victims, I am going to now reserve all of the benches behind the prosecution table for victims. They will no longer be available for media or the public. From my perspective, there's ample room on the other side of the courtroom. I'll ask the district court administrator to assist me in modifying the trial administration order, but that was my observation throughout. Ample seating, that does take away a bench from the media, but from my perspective, they've been watching, I think, from the media room based upon the pool feed, and they no longer need the 2 benches.
Thank you, Your Honor. We greatly appreciate that.
You're welcome. All right, then I'll have the jurors brought out momentarily. I just want to get confirmation from the bailiffs who are with Mr. Brooks that they offered, based on my direction, Mr. Brooks to come back over here. I don't know what his response was. Mr. Brooks, I'll ask you and advise you, you are welcome to come back to this courtroom. You've been conducting yourself in that courtroom, at least prior to the break, in a way that seemed to me that you were writing notes, perhaps even following along with the written jury instructions. I know you filed 2 objections. Those were addressed earlier. Mr. Brooks, if you're willing to abide by the rules of courtesy and decorum, you are welcome to come back. Would you like to come back to the main courtroom?
Can y'all hear me?
You're on the record. Would you like to come back to the main courtroom? And if I could just get confirmation from the bailiffs. I know the audio was tested. I was under the impression it was working, both audio and visual.
It just shut off.
Do we know if anything what I said was picked up?
It was.
Okay, thank you. Looks like Mr. Brooks has put on the headphones and they're testing them to see if they are working. I don't believe he had those on prior to the break.
My notes show he had removed them at about 10:54 a.m. and when we broke for lunch, it was about 11:54. So it was about the last hour of the morning session. He was not wearing the headphones, Your Honor.
Thank you. I believe those headsets do need to be charged on occasion, so there are other headsets that can be provided if that one is not working. Looks like a new battery pack, charger pack for that was provided. It's not the headset, but the attachment that gets charged, so hopefully that works.
We're all set.
All right, Mr. Brooks, I am offering you an opportunity to come back to the main courtroom. Would you like to do that? I'm not sure why we're not hearing him very loud at the moment, but can you repeat that again?
I say yes.
You'd like to come back? All right, we'll have you brought back then. Thank you. We'll be in recess until that is accomplished. It's 1:22. The record should reflect that Mr. Brooks is back in the courtroom. I do want to make a further record that he still remains in his jail attire. Prior to the break, I did advise the captain and to let Mr. Brooks know that he certainly could take the opportunity during the lunch hour to put on street clothes. So it's his choice. He is here in the jail attire. He's at the table, continues to be masked. Welcome back, Mr. Brooks.
Just for the record, Your Honor, they never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Thank you. I appreciate that clarification. Nonetheless, I provided you with that opportunity, and here you are. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would, of course, be subject to removal and forfeiting your right to be present in this courtroom. All right, I'd like to bring the jury out, Mr. Brooks. I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point not to object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about objections to strictly jury instructions or the filings that I filed on the 3rd?
I'm not addressing those at this point,
I
sir.
was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about objections during this court hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
Right. I'm not addressing any of those filings. I've previously addressed those. It may not be to your satisfaction, but,
Remember what you said, to be honest, about those.
and I'm not going to repeat myself. So the record speaks for itself. Your objections in those filings, to the extent, whatever they are noted. They're part of the record. And they will be available for you at a later point in time should you be convicted and on appeal to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
Reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken. We're not at that stage of the proceedings. So you will have an opportunity after the state presents their case in chief and they rest to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure, but I expect you to not bring that up at this point in time or going forward.
I don't understand, though, Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions. I am, just for reference for everyone, I've read through 44 pages of 69 And so I still have a ways to go. My intention would be to finish with the preliminary jury instructions, take a short break for all, including the jurors, and then come back with opening statements. And that's, you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof. And then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction? That still
No,
has
there's
to be
no
approved?
lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr.
bring
Brooks,
up
I'm
subject
going to
matter
bring the
jurisdiction?
jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor. I
Your
respectfully
objection to my characterization of that is noted.
I would like to make a motion for finding the fact then.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the disadvantages. You were advised of things, including the charges that you face, the penalties that go along with them. We discussed the difficulty of representing yourself. You made a deliberate choice to waive your right to an attorney, which this court honored and granted.
That is inaccurate
And
because
you,
I
Mr.
altered
Brooks,
the
don't
contract.
interrupt me. Okay, now we're that's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It is not my
please,
intent.
I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I'm
All
not
right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you.
So what are
The
you
fact
gonna
that
say?
you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's That's your assessment is not accurate.
Well, my assessment will stand on the record, sir. It's
And
based
so-
on my observations.
And
So,
I
at this
respect-
point, Mr. Brooks,
I respectfully object
Stop
to that.
interrupting me, please.
I merely
Stop
just seek to
interrupting me,
understand.
sir.
I'm not. I was
If
in the
you
middle
have
of
an
saying
objection, write it down.
something. I thought that applied to me being.
It's
from
applying right
another-
now since you keep interrupting me while
So
I'm talking.
what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there
All
a
right,
reason
I'm
why?
not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's inaccurate.
but I have addressed them.
That's
All right,
inaccurate, Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filings do not require a specific line-by-line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be.
It doesn't
But
have
we are
anything-
continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case.
Your
Madam
Honor.
Clerk, have the jurors brought
Your
in,
Honor,
please.
What you're doing is judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings and I should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the waiver back in the way that I felt that it should be altered, and you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That should have let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the
Do
proceedings.
you
It is not to.
understand when I tell you not to interrupt me?
No,
Do you
no, I do not.
understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I still would like to ask
Mr.
questions,
Brooks?
Your Honor.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect,
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr.
that
Brooks,
you have
the
not
jury
shown-
is in the courtroom.
I understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It's my right.
Mr.
I'm
Brooks,
merely
you
exercising
can
my
stand.
right.
You need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
I'm seeking to understand, Your Honor. It must be some clarification.
Mr. Brooks, I want you here.
I want to be here.
Stop interrupting me.
You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, cannot.
Ladies and gentlemen of the
You can-
jury,
you can
I'm going
move
to
me to the other
continue
thing.
with the jury instructions. I'm on count 38. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 38. If you are not so satisfied, you must find the defendant not guilty as to count 38. If you find the defendant guilty of count 38, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first degree reckless endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty as to count 39. If you find the defendant guilty of count 39, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 40, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 40. If you are not so satisfied, you must find the defendant not guilty as to count 40. If you find the defendant guilty of count 40, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 41, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 41. If you are not so satisfied, you must find the defendant not guilty as to count 41. If you find the defendant guilty of count 41, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 42, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 42. If you are not so satisfied, you must find the defendant not guilty as to count 42. If you find the defendant guilty of count 42, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 43, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 43. If you are not so satisfied, you must find the defendant not guilty as to count 43. If you find the defendant guilty of count 43, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 44, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 44. If you are not so satisfied, you must find the defendant not guilty as to count 44. If you find the defendant guilty of count 44, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 45, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45. If you find the defendant guilty of count 45, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 46, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 46. If you are not so satisfied, you must find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 47, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 47. If you are not so satisfied, you must find the defendant not guilty as to count 47. If you find the defendant guilty of count 47, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 48, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 48. If you are not so satisfied, you must find the defendant not guilty as to count 48. If you find the defendant guilty of count 48, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 49, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 49. If you are not so satisfied, you must find the defendant not guilty as to count 49. If you find the defendant guilty of count 49, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree reckless endangering safety have been proved as to count 50, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 50. If you are not so satisfied, you must find the defendant not guilty of count 50. Sorry, I lost my place. I hope that was all related to count 50 because it was. I'll just start at the top of that again. If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 50, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 50. If you are not so satisfied, you must find the defendant not guilty as to count 50. If you find the defendant guilty of count 50, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 51, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 51. If you are not so satisfied, you must find the defendant not guilty as to count 51. If you find the defendant guilty of count 51, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 52, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 52. If you are not so satisfied, you must find the defendant not guilty as to count 52. If you find the defendant guilty of count 52, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 53, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 53. If you are not so satisfied, you must find the defendant not guilty as to count 53. If you find the defendant guilty of count 53, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 54, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 54. If you are not so satisfied, you must find the defendant not guilty as to count 54. If you find the defendant guilty of count 54, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 55, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 55. If you are not so satisfied, you must find the defendant not guilty as to count 55. If you find the defendant guilty of count 55, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 56, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 56. If you are not so satisfied, you must find the defendant not guilty as to count 56. If you find the defendant guilty of count 56, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 57, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 57. If you are not so satisfied, you must find the defendant not guilty as to count 57. If you find the defendant guilty of count 57, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 58, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 58. If you are not so satisfied, you must find the defendant not guilty as to count 58. If you find the defendant guilty of count 58, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 59, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 59. If you are not so satisfied, you must find the defendant not guilty as to count 59. If you find the defendant guilty of count 59, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 60, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty of count 60, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 61, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 61. If you are not so satisfied, you must find the defendant not guilty as to count 61. If you find the defendant guilty of count 61, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that, oh darn it, I think I skipped a few numbers. Maybe not. I think I'm okay. Did anyone think I skipped any numbers? Okay, good. Sorry, it's a lot of numbers. And I do the best that I can, and I was a little distracted by a piece of paper that was put in front of me. So we are on 61. If you find the defendant guilty of count 61, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 62, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 62. If you are not so satisfied, you must find the defendant not guilty as to count 62. If you find the defendant guilty of count 62, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 63, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 63. If you are not so satisfied, you must find the defendant not guilty as to count 63. If you find the defendant guilty of count 63, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 64, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 64. If you are not so satisfied, you must find the defendant not guilty as to count 64. If you find the defendant guilty of count 64, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 65, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 65. If you are not so satisfied, you must find the defendant not guilty as to count 65. If you find the defendant guilty of count 65, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 66, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 66. If you are not so satisfied, you must find the defendant not guilty as to count 66. If you find the defendant guilty of count 66, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 67, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 67. If you are not so satisfied, you must find the defendant not guilty as to count 67. If you find the defendant guilty of count 67, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? And just for a moment, since I'm going on to a next section, let's just stand for a minute. All right, please be seated. The defendant is charged with 6 separate counts of violating a duty after being involved in an accident resulting in death. The 68th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Virginia Sorensen and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible, and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 69th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Leanna Owen and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, hospital, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person. Contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 70th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Tamara Durand and failed to reasonably investigate what was struck and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 71st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jane Coolidge and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible, and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, a surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary, or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 72nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Wilhelm Hospital, and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible, and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary, or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 73rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jackson Sparks, and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible, and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary, or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. Section 346.67 of the Wisconsin statutes, commonly referred to as hit and run, is violated when the operator of any vehicle involved in an accident on a highway fails to reasonably investigate what was struck, and if the operator knows or has reason to know that the accident resulted in death of a person, fails to stop the vehicle he is operating as close to the scene of the accident as possible and remain at the scene of the accident until the operator has given information and rendered reasonable assistance to any person injured in the accident. Before you may find the defendant guilty of any count of hit and run, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present with respect to that count. 1, as to each count, the defendant operated a vehicle involved in an accident on a highway. A vehicle is operated when it is set in motion. 2, as to each count, the defendant knew that the vehicle he operated was involved in an accident on a highway. 3, as to each count, the defendant violated a duty after being involved in an accident. A driver who is involved in an accident has 2 duties. The state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the 2 duties, but you are not required to agree as to which duty was violated. The first duty is to reasonably investigate what was struck. The second duty is that a driver involved in an accident involving a person must stop and provide information and render aid. To prove a violation of this duty, the state must prove the following beyond a reasonable doubt: that the defendant knew or had reason to know that the vehicle he was operating was involved in an accident involving a person, and that the accident resulted in death of a person, and that the defendant did not immediately stop his vehicle as close to the scene of the accident as possible and remain at the scene until he had done all of the following: gave his name, address, and the registration number of the vehicle he was driving to the person struck, and if it was requested and was available, exhibited his operator's license to the person struck, and rendered reasonable assistance to any person injured in the accident, including the transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or is requested by the injured person. 4, the defendant was physically capable of complying with these requirements. You cannot look into a person's mind to find knowledge. What a person knows or has reason to know must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. The information alleges not only that the defendant committed the crimes of hit and run, but also that the accident resulted in death to a person. If you find the defendant guilty of a count of hit and run, you must answer the following question: yes or no. Did the accident involve death to a person? Before you may answer yes, you must be satisfied beyond a reasonable doubt that the answer to that question is yes. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Virginia Sorensen? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 69, you should find the defendant guilty of hit and run as charged in count 69. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Leanna Owen? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 70, you should find the defendant guilty of hit and run as charged in count 70. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Tamara Durand? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jane Coolidge? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 72, you should find the defendant guilty of hit and run as charged in count 72. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Wilhelm Hospital? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 73, you should find the defendant guilty of hit and run as charged in count 73. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jackson Sparks? The defendant is charged with 2 separate counts of bail jumping. The 74th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Section 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. The 75th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Sections 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. Bail jumping, as defined in Section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of that bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of his bond. This requires that the defendant had the mental purpose to fail to comply with the terms of the bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, and battery. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, or battery. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definitions here. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. If you are not so satisfied, you must find the defendant not guilty as to count 75. The 76th count of the information charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, at Frame Park in the city of Waukesha, Waukesha County, Wisconsin, did cause bodily harm to Erica Patterson by an act done with intent to cause bodily harm to that person without that person's consent, contrary to sections 940.19 sub 1, 939.51 sub 3 sub A, 968.075 sub 1 sub A, all of the Wisconsin statutes. Battery, as defined in section 940.19 sub 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find the defendant guilty of battery, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. 1. The defendant caused bodily harm to Erica Patterson. Cause means that the defendant's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. 2. The defendant intended to cause bodily harm to Erica Patterson. Intent to cause bodily harm means that the defendant had the mental purpose to cause bodily harm to another human being or was aware that his conduct was practically certain to cause bodily harm to another human being. 3. The defendant caused bodily harm without the consent of Erica Patterson. 4. The defendant knew that Erica Patterson did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved as to count 76, you should find the defendant guilty of battery as charged in count 76. If you are not so satisfied, you must find the defendant not guilty. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The parties will make opening statements. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Before we have the parties before I give them the opportunity to make opening statements, I am going to excuse the jurors to address a few legal matters, give you an opportunity as well for a short comfort break. We'll let you know when we bring you back in. I think you'd be seated. We'll go over these. Oh, sure. All right, how many pieces of paper do I have?
One got a little closer, that was.
A number of pieces of paper that Mr. Brooks wrote on. I'm going to have them copied so the state can be aware of that and respond if necessary. So we'll just take a moment while those papers are copied.
Did it not work?
I called them, but all right, I'll call again.
We will follow up.
How many copies are you making? 2? Yeah, okay. We'll make sure you have copies of the filings as well, so you know what will be discussed, or at least addressed in some fashion. But I need to provide copies to the state. Go ahead, sir.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now, so I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs. So it was no way for me to even see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what knowledge they had about proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now, that's how I'll address it. I'll advise you of what her answer is later.
Do we know the number?
Do you know the number of the jurors, sir? They have numbers.
I just know that I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the top or the bottom row?
The bottom row, the last black chair. Black shirt. She had the black
They're
shirt
all
on.
black chairs, sir. So
The last
chair
black
closest-
chair closest to the television.
Thank you, sir, because there are two sides, right? So there's the last chair on both sides. So I wanted to make clear. You're saying the chair closest to the television. Thank you.
I said that at the beginning, Your Honor.
Front row. All right. State have copies of the filings.
Yes.
I will take these in order. The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, "I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit, filed 10/3/22, which today is deadline to respond." Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings. That's my decision, sir. Next
Are you
topic.
making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding a fact.
Your request is denied. The next,
May Your Honor explain why it
Mr.
is
Brooks,
denied.
I'm gonna go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making the error, Your Honor.
Mr.
You wanna
Brooks,
explain
I'm
to
not
me
going to
why?
have a debate with you right now. We
I'm
are
not.
continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52
I still would
p.m.
like a judicial. Are you making
says,
a
are
judicial
you making a
determination?
judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law. There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not disruption.
Mr. Brooks.
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard in court, will that be honored by your honor? That's a valid question.
Mr.
Because
Brooks,
that's a constitutional
I have
right.
given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even
So-
get these admitted into evidence.
That's, Mr. Brooks, I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand. But
So,
I was
but that
following-
doesn't mean we're going to have a
I was
discussion
following- no,
or a
I'm not
debate
trying to debate
about
with you,
what
but I
it
was
means, because we're
following-
not
I
going
was
to do
following
that.
the rules that you said.
So the bottom
by
line is, I
writing
don't
and
feel,
sending it.
Mr. Brooks, stop talking. I do
No,
not
I was
feel,
right. I was following the rules when you said that I had to make all
and you
objections.
did, and I'm going through
in
them,
writing.
so give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All I'm
Brooks,
saying is,
I'm going to address the next one,
what
so
you-
please pay
what you
attention.
were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's
Brooks,
all I'm merely-
again, you have the right to present a defense, but that right is not unfettered.
But that's under
That
the Sixth
right,
Amendment. I'm
Mr.
talking
Brooks,
about the First
you
Amendment.
are interrupting me. Stop.
Because you're talking about
No, because you're
talking about an
purposely
amendment that I'm
doing
not
this,
referring
so
to,
I
Your Honor.
can't get my reasoning
But
out.
I'm
You
not
make it
referring to the
incredibly
Sixth
difficult.
Amendment. I'm not referring to the Sixth Amendment.
Mr.
I'm referring
Brooks.
to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial. What
Mr.
you're
Brooks,
doing
you
is
also
not
have
fair
an
and impartial.
obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence.
Your Honor, I did
That's
not-
the playing field that you willingly entered into and made a deliberate
did not.
decision to waive your right to an attorney
I
and
cons-
to appear
I
in this
consented-
case as your own
I consented
attorney.
to represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right
You also
now.
accepted the terms of the paperwork that I
Mr.
filed out.
Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage in
We did
any
not.
type of
We
that
did not
kind of
enter into
dialogue.
any
Because
contract.
that's what you're claiming through some
No,
of
I'm
these
not.
filings,
I'm
and
not
you've said
claiming
that previously.
I am not claiming that, Your Honor.
So,
In any way,
Mr.
shape, or
Brooks,
form, I do
am
not
giving you
consent to
some
any
leeway.
contract.
You continue to talk over me. It's, you please, I'm asking you to follow the rules of civility. Simple rule, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down.
You did.
Anything that I object to and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's
So,
being asserted on
here's
my
what's
end.
happening, sir.
All
I'm
I'm-
telling you,
all
I'm
I'm asking
advising
for-
you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other courtroom so that I can do this.
This is-
And yes, exercise the mute button, sir.
This
But,
is-
and
this
then
is
I'll bring
something
you
that was
back when the
filed, though.
jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is
it's valid.
clearly not following the simple rule of civility that I have established.
That's
He
inaccurate,
continues
Your
to
Honor.
interrupt. He's not providing
That is
this court with
inaccurate, Your
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor my First Amendment right?
I'm
Or
not
are you
answering
making
that
it- or are
question,
you
sir,
making
because
it-
I've already addressed
So
it.
you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination,
So
sir.
you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have
Sixth
a right
Amendment,
to
not
be
the First.
present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
your
are, Your
rights,
Honor. You're citing the Sixth Amendment, which I am not
Mr. Brooks.
questioning.
Your
I'm-
First Amendment, in some respects, is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So that
freedom
doesn't
of
mean you
speech?
get to say anything that you want in
No,
front of
I'm-
a jury.
Your
And it
Honor.
doesn't mean you get to put forth any kind of evidence that you want
Your
in front
Honor,
of a
am
jury.
am I
What it
being-
means, sir,
am
is
I being
that you
disrespectful?
must
Am I
follow.
calling you
Yes,
out your
you're being
name? Am I threatening
disrespectful because
anybody?
you're
I'm not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeit his right to be
I have
present
not
as I
forfeited
go
my right,
through
Your Honor. I have
his
not consented to any. I'm
his
simply trying to
paperwork. He's to be
understand
removed to the other courtroom
I'm
until
simply
such
trying to
time as he
understand
can pledge to
why we're
follow
not
the
talking
rules
about
of
the First
decorum and
Amendment. I'm not
civility.
talking about the
We'll be
Sixth
in
Amendment.
recess until we have
Your
everything
Honor, I do
set
not
up.
agree to a
The
estoppel.
record to reflect, I'm stepping off. The Michelle's not here, so we are not on the record. I just want to test. The record should reflect that Mr. Brooks is now appearing from the other courtroom. Prior to the court taking the short break, the court was attempting to address the filings from Mr. Brooks that he made pursuant to my request to write down if he had an objection. I have 5 different, what I will refer to as filings, one of which he provided to Deputy Wittig at 12:05, so that was right around the time we broke for lunch. A second one, 1:52 p.m., today's date, October 6th, and then there's another 1:58 p.m., October 6th, 2:03 p.m., October 6th, and then looks like the time is 14:28, so 2:28. The other one was received. Mr. Brooks, I'm going to make a record first as to why you've been removed, and then I will hopefully get to the filings. I need you to not interrupt me at the moment. You are unmuted. But after the court completed the preliminary jury instructions and the reading that is to the jurors, I excused the jurors so that they could take a break, but also because I knew there were a number of what I will loosely refer to as objections that were raised by Mr. Brooks. So I wanted to take an opportunity to address those first before moving on to opening statements. As I attempted to address those with Mr. Brooks, there was, from my observation and opinion, and I'll make a finding that it was pretty much a consistent talking over me by Mr. Brooks. I wasn't able to really go through any of these filings with any specificity. I attempted to go through the first one, which I did. I mean, I did tell him I wasn't going to address that. And then we were talking about his second one when really it kind of devolved from there. The record is very clear that Mr. Brooks has been advised on multiple occasions of my expectation regarding courtesy and decorum in this courtroom. I've referred to it many times that there's a very simple rule of civility I expect him to follow at a minimum, and that is to not interrupt. It shows a complete and utter lack of respect for the court process, the court proceedings. It interrupts the court as the court is attempting to make a record of what is happening and decisions that I am making. And after repeated warnings to him, the court made a determination that he had forfeited his right to be present in the courtroom while we discuss his filings the record will reflect that Mr. Brooks did not give consent. I am still continuing with my findings, sir, so I'd ask that you not interrupt me. Mr. Brooks, I'm not done. I'm going to mute him because frankly, can be difficult to keep one's train of thought when you are consistently interrupted, which is why I believe he engages in the conduct that he does, because it's plain and simple, it is disruptive. It disrupts my thought process, it disrupts the proceedings. I was so pleased, Mr. Brooks, when you were able to follow the simple rules when the jury was here and I was going through the jury instructions. I know you had some objections, you wrote them all down, you followed that procedure. I told you I would take those up after I got through the jury instructions. I was attempting to do that, but then you started in with your antics, with your interruptions. It doesn't matter to this court if you're mild-mannered, if your tone of voice is a normal tone of voice, meaning it doesn't matter to me that you're not raising your voice, you're not making any threats or anything like that. That certainly would take things to the next level, in my opinion, but it's not necessary for this court to make a finding that your behavior is disruptive. And this obviously comes on the heels of your conduct this morning, where you spent the vast majority of the morning in the other courtroom based upon your conduct. And I'll once again rely on the decision in Illinois versus Allen, 397 U.S. 337, a U.S. Supreme Court case from 1970 on the options the court has constitutionally when faced with a disruptive defendant, someone like Mr. Brooks, who cannot conduct himself consistently with the decorum and respect that is inherent in the concept of courts and judicial proceedings. The consistent interruptions are not only disruptions, but it interferes with the proper administration of this trial. It disrupts the dignity, order, and decorum of this court. Those are the hallmarks of all court proceedings. I'll make a finding that he flagrantly disregards in the courtroom elementary standards of proper conduct by repeatedly interrupting this court. And therefore, he has forfeited his right to be present while we discuss all of these filings. I'll also make a finding that the technology that we are utilizing here today, we are Polycom to Polycom. The audio and video have been working very well this afternoon. No issues with that, and that it's the functional equivalent of Mr. Brooks being in this courtroom. It gives him the opportunity and the ability to meaningfully participate while the court is still able to control his behavior by exercising the mute button, as I have repeatedly throughout these proceedings. I believe all of the documents speak for themselves, I should say, but what I will do is go through them one by one from the beginning. Since they're Mr. Brooks's filings, his position has been made known. I'll ask the state to respond. If I feel any additional follow-up is needed from Mr. Brooks, I'll ask him for that, and then I'll make a decision. So even if that's backtracking a little bit, it's a little bit easier to do that with him in the other courtroom. So the first one that I will deal with is the one that's got today's date and 12:05. I addressed it earlier in terms of that I did not believe it was a filing that required any court response, and I'll ask the state if the state sees any of that differently.
No, Your Honor, and I would cite the court's United States versus Benabe, B-E-N-A-B-E, at 654 Fed 3rd 753. It's a 7th Circuit case from 2011. Specifically, there's very instructive language on page 767. This case involved a defendant who identified himself as a sovereign citizen. The court goes into a nice discussion as to such claims having no merit whatsoever. The quote is, the proposed sovereign citizen defense has, quote, no conceivable validity in American law. I think that's applicable to several of these filings here, Your Honor, and I think that's relevant authority throughout the remainder of this trial, that these sovereign citizen defenses have been attempted. There's a lot of cases on this. That's the most recent from the Seventh Circuit that I could find. In no way have any of these defenses, such as his name, the jurisdiction of the court, the fact that the state's an entity, any of these efforts that Mr. Brooks has tried to put forth have been soundly rejected by the courts, and there's significant case law on point, but that's the most recent and appears to fit really well with the facts of this case.
I would note the documents he refers to in this particular piece of paper references the notice of special appearance, the statement of particulars, both are by affidavit. Those are two of the common sovereign tactics, and I believe Benaby and the language that you cited is directly on point, and that is why I can simply deny the request to address those filings without any further discussion or hearing on them, even without giving Mr. Brooks an opportunity to further respond. The second statement, and I note he's raising the objection, and I'll indicate for the record he's objecting to what's being ruled upon. Then the second filing, we heard him discuss at length, so I'll just have the state respond to that, and that was his claim that his First Amendment rights to freedom of speech are not being honored in this courtroom.
So the court has been abundantly patient in allowing Mr. Brooks to make appropriate, relevant legal arguments. The court is 100% accurate that no constitutional rights is absolute, and there is they can be fettered under appropriate situations, and you've made an excellent record as to why that is appropriate in this case.
Mr. Brooks is raising his objection sign. Since he was given an opportunity to address this previously, I'm not going to give him further opportunity and simply indicate that he will be allowed at appropriate times under the rules of evidence, under the to present his defense. It appears to me at times he may confuse the ability to file something into the record with the ability to present evidence. We have yet to start the evidentiary phase of this trial. In addition, any of his specific objections should be brought by motion. Even if that's an oral motion, it should be based in law and fact and request specific relief. His filings make claims that have no underpinning in law or fact. It's really conclusory. This court is under no obligation to address, conclusory statements by him that are not properly made, both in form and in substance. This record's replete with references and instances of Mr. Brooks just simply spouting various amendments or theories without those fully being established in the record. And again, no constitutional right is absolute. The First Amendment rights of an individual can certainly be fettered. That is especially true in a court of law where there are rules of evidence, rules of procedure, where we have the standards of courtesy and decorum. He can present his defense. He has a right to present a defense, but his rights to do that must comport with the law, and that law is what I've already pointed out. So I'm not sure really how to address, are you making a judicial determination? Everything that I do when I rule on something is a decision that is made by this court. So I've answered this. We'll move on to the next one. And he is raising his objection, and that's fine. He can do that. His objection will be noted for the record. He also raises in the next filing at 158, I still motion to prove jurisdiction, please. Also motion to dismiss for no proof of jurisdiction. Also motion for finding of fact. Again, none of these things cite to any legal authority or any factual basis, nor do they request any specific relief. Here's what I will rely upon the Beneby decision from the Seventh Circuit, that these are just various arguments raised by sovereigns that have been debunked and have been addressed that have no place in our justice system. And therefore, I will deny the requests in that piece of paper summarily without further consideration. I know he makes repeated objection to either how I say his name or how it's referenced in the caption. There's a continuing objection that I will note. His filings speak for themselves, how he wishes to be addressed. This court will refer to the name that is on the information in this case. That is the official charging document. And that is what I will do. If I mispronounce his first name at times, my apologies. I know I said his name repeatedly throughout those jury instructions. I know when I first had hearings on this case, even his own attorneys referred to him as Daryl. And it was only after I viewed his recorded interview that I learned it was Darrell. I asked him at one hearing, how do I say your name? Is it Darrell? And he said, that's right, or words to that effect. I may not have the exact quote, and I'm not quoting him, but he confirmed for me on the record, at least at that point, what his first name was. So his continuing objection about his name is so noted. It's preserved in the record based upon his filings, and I'm not going to address it further. Frankly, his last document, which says a plea is to argue facts, I don't intend to do that, and I never agreed to or consented to a, quote, not guilty, quote, plea. My attorneys never got my consent for a not guilty plea. I don't understand. The law is very clear that a plea of not guilty, even when a defendant stands mute, is what the court proceeds with. It is true in this particular case that plea was entered on his behalf, but the fact also remains that in order for that plea to be changed to something else, meaning a guilty plea or a no contest plea, the defendant would need to go through the plea questionnaire waiver of rights form and have to knowingly, freely, voluntarily, and intelligently waive all of the rights that go along with that. In other words, this court is simply constrained by the law to proceed as if not guilty pleas were entered on his behalf. So I've addressed that. I don't need any further argument from the parties. I will note Mr. Brooks continues to have the objection sign raised. The other thing I want to make a record of, we did have the civilian jury bailiffs check with the juror that was identified by Mr. Brooks, and that juror confirmed she has not attended any proceedings. So that issue is addressed now. He's holding up his objection sign. Mr. Brooks, I frankly did that for your benefit. You raised what really is an important issue, and I appreciate that. I was a little surprised by it, but then when I heard you explain further, I thought, he's got a point there. He had been removed for some of those proceedings. You may not have seen her. I'm not making a finding on that, and so that's why I backtracked a little bit, said I would look into it. So I'm not sure why you're objecting at this point. I took an important piece of information that you were relaying, and we had it, in this case, it was confirmed that the juror did not attend any proceedings, and so that will address your issue with her. All right, now the next step would be opening statements. So, Mr. Brooks, you have demonstrated in the past, and I'm going to unmute you, that when the jury is present, you are able to maintain civility, show them respect, show the courts and the process respect and dignity. I certainly am willing to have you brought back over while the state gives their opening statement, and certainly if you choose to make an opening statement, for you to do that in this courtroom in the presence of the jury. I know you're holding up your objection sign, sir, but I am giving you the opportunity to come back over here. Would you like to come back to this courtroom? Record should reflect he's holding up his objection sign. It appears that he's writing I don't know what, of course. Mr. Brooks, I'm going to ask you again. Would you like to come back to this courtroom for opening statements?
So I'm on the record.
You are. If you would please address my question.
So you want me to come back over there just to get brought back over here?
That's not what I asked you, sir. I told you, I advised you I would like you back here. It's always my preference that you're here. You demonstrated previously that you can follow some rules when the jury is present. The jury's going to be brought back in shortly for opening statements. The state will go first as they bear the burden of proof, and then you will be given an opportunity to also present an opening statement. So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm going to get sent out.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response. If you follow the rules of decorum and courtesy and civility, you will remain. But if you choose to
You're
not
saying
do that, then you run the risk of once again forfeiting your right to be present.
You say that even though I never consented to being taken out. You say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive. And I don't understand why everything I say has to have some type of disruption title to it. It's even been put on record numerous times with inaccuracy. Even what happened today, nobody reported on record about me being bruised up and having to get bandaged up and all these things, but it was put on me, laid at my feet, as if me, quote unquote, being disruptive was deserving of what happened to me. I'm simply trying to have a fair trial. And if I don't, forgive me for being this way, Your Honor, but if I don't understand, I'm going to ask questions. That's the only way I can have clarity, is by asking questions. And you have refused to answer anything, but I have to answer everything you ask me. Where's the give and take? It should be fair. I'm not asking for legal advice. I'm not asking for nothing like that. I'm asking to simply have clarification so that I can understand. I cannot put on an adequate defense if I don't understand something. Do you see these boxes I got right here? Do you think I was able to go through everything in those boxes?
Mr. Brooks, I'm not going to go through this with you again, where you attempt to put on the record all of these issues that you have when we're in the middle of a trial. All right? You willingly waived your right to an attorney. I made all of those findings, so we will go forward.
You made those findings.
I am not obligated to answer questions.
You made
when
those
you ask me
filings.
questions, I'm going to mute him.
Yeah.
I am not obligated to answer questions that explain procedure or the law. I am obligated to address motions to address that are based in law and fact. I'm obligated to address objections, for example, whether it be to testimony or evidence or questions posed to witnesses. But I am not obligated, sir, to provide you with an explanation of the law, of the procedure. And with that, since I gave him 2 opportunities to answer a very direct question, and that was, do you want to come back to this courtroom? And he chose not to answer it, but instead ask a question and then start making statements about his lack of understanding, I will find that his non-response, that he has not answered directly, which to me says he's not willing to follow the rules of decorum and courtesy and civility, and without such a pledge, he will remain in that courtroom. He's muted. The record should reflect. It appears he's talking as well. He's making hand gestures. His lips are moving behind the mask. And I just wanted to make a record of that. All right. Then we will have the jurors brought in, and then the state can then proceed with its opening statement. That's a multi-count instruction, and so that's why you gotta look back the way it normally would.
Oh, okay.
Mr. Mitchell's doing the opening. Okay, thank you. Thank you, Teresa. Sure. Be seated, everyone. All right, at this time, we will give the parties the opportunity to make opening statements. Does the state have an opening statement?
Yes, thank you.
And just for the record, Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury. Go ahead, Attorney Wichow.
Thank you. Madam Clerk, could I have the screen projected?
Middle. On your table.
I just, when we do that, make sure we confirm it should transmit, but we'll make sure it's transmitting over there as well. And if that's okay if it happens. We may lose video of Mr. Brooks for the time being, as the state is using what appears to be a PowerPoint. Just confirm with me, Deputy Wittig, that when it starts that it is able to be viewed and heard over there. Go ahead.
It was a cold.
They can't see it? All right, hold on. I may have to utilize the Zoom for that then, so it's... All right, let me do this. No one needs to leave. We're gonna go off the record though, so that I can set up another way to do this so that there's a share screen capability. Okay. Record, we have the technology problem solved. So go ahead, the state may present its opening statement.
It was a cold and windy Sunday afternoon in November. Thousands of people were bundling up and going downtown to watch the annual Waukesha Christmas parade. The event started off normal. There were dance teams, high school marching bands, local community groups, local businesses, all making their way down the parade route. The streets were lined with friends and family members and neighbors, people there to soak up the atmosphere. Kids ran into the street to grab candy from the people who were throwing it from the parades. It sounds corny, but I think you'll see from the videos there was a true sense of joy in the air. Darrell Brooks killed that joy. He replaced it with terror, trauma, and death. The evidence is going to show that Mr. Brooks left behind a trail of carnage and chaos as he made his way down Main Street through the parade route. The evidence will show that he left that crime scene, created that crime scene, in fact, because he was fleeing from another one where he had laid his hands on a woman and where police involvement became inevitable. So as he careened down Main Street, swerving from curb to curb, hands glued to the steering wheel, eyes fixed on the road in front of him with a silent rage on his face, he hit the gas with his red Ford Escape and used it as a battering ram over and over again, striking men, women, and kids. In the end, Mr. Brooks killed 6 people. He injured dozens more and left a permanent scar on this community. We are going to present evidence to you over the next several days in chronological phases, in order of events, from start to end. I'm going to take a few minutes. I'm going to lay out for you the table of contents to this story. We're going to set the scene with Sergeant Dave Warner from the City of Waukesha Police Department. Sergeant Warner was the highest-ranking police official working at the parade that day. He was the incident commander for the Waukesha Christmas Parade, and we are going to, with Sergeant Warner's help, take you through this, which is the first of 3 maps that we will refer to repeatedly throughout this trial. This map depicts the area that we're going to be talking about over the next couple of days, the parade route. Now, for those of you not entirely familiar with downtown Waukesha, this is going to look like a bunch of gibberish, but once we get going and we repeatedly refer to these street names and the business names and the groups that were involved in this parade, I think it'll become like a second language to you. Sergeant Warner will describe for you how the parade route ran from, if you look closely at the screens in front of you, the intersection of Main Street and White Rock Avenue. White Rock was a staging area for the parade groups and floats. And they made their way southeast on White Rock until they came to Main Street, and then they would make a right turn and head southeast down Main Street through the parade route until the very end as it wraps around to the south and runs into Wisconsin Avenue. The parade route then would continue to the east, making a left-hand turn on Wisconsin, but nothing really happens on Wisconsin Avenue. You're not going to hear any testimony about that. As you can see from this map, it depicts or represents each intersection where a squad car or a police officer was stationed. They're denoted by the little badge shields in the intersections. If you look closely, you can see little red lines, and Sergeant Warner will describe how those represent the barricades that were placed at each intersection for security and safety purposes. Once we've got that established, we're going to move into the first chapter of this story, and you're going to hear about the origin of Mr. Brooks' rage that day. A violent domestic argument with Erica Patterson, his former girlfriend and the mother of his child. Erica Patterson is going to testify either today or tomorrow, hopefully today. She's going to tell you that in November of 2021, she was staying at the Women's Center, which is a shelter here in Waukesha. And on the day in question, November 21st of 2021, the defendant showed up in Waukesha in his red Ford Escape that she knew he drove, and he argued with her, and he harassed her, and he punched her in the face. And the thing about a swollen eye is it's tough to fake. You're going to hear evidence about how after, let me back up. You're going to hear evidence about how the defendant took Erica Patterson all over town that afternoon. From Frame Park, across the river, up Barstow Hill, back down to Frame Park. And at some point, after she was struck, after she sustained that injury, Erica called her friends because she needed help. And she had no one else to call. One of those friends is Corey Runkle. You're going to hear from Corey on the witness stand in this trial. Corey's going to say that she was Erica's roommate at the Women's Center. She had known Erica for a few weeks and they had grown close. And when she got the call from Erica that Erica needed help, Corey immediately responded to help. And she ended up finding Erica and Daryl Brooks in front of the White Rock School. If we go back, the White Rock School is on White Rock Avenue. It's on near the top right portion of the map. It's just south of Frame Park. And Corey is going to talk about how she found Erica and the defendant at this location, and she got into both a physical and a verbal altercation with Mr. Brooks. That altercation is captured on surveillance video, 2 surveillance videos actually. You're going to see both of them. You're going to see how the defendant was reacting that day. You're going to see what he looked like, what he was wearing, the red Ford Escape that he was driving. You're going to see how the defendant reacted once Erica's friends showed up and he lost his physical advantage over a woman. Erica and Corey will also testify that at some point during this scuffle, the police were called. And you're going to see a separate video, a squad video, from the responding officer that shows just down the block there was a marked squad car with its lights flashing, marking the entrance to the parade. Something that people in front of White Rock School would have seen. So the evidence is going to show that the defendant must have known. Once things got loud, and once there was more than just him and Erica on scene, the police were going to show up. So he took the coward's way out. You're going to see him in the video get into the driver's seat of that red SUV. Corey and Erica will tell you that no one else was in the car. And you're going to see him pull off on White Rock towards Main Street. You're going to hear from law enforcement officers who were positioned along the parade route. The officers who made their initial contact with the defendant, the first ones who tried to stop him. And the first one is Detective Tom Casey, the lead detective in this case. He's sitting at the state's prosecution table right behind me. He's going to tell you that he was working that day as security for the parade. He was working at Main and White Rock. He's the first law enforcement officer to come into contact with the defendant during this incident, face to face. Or I think better describe it as face to windshield. He tried to stop the defendant, but there's only so much a man can do against an SUV. But he's going to tell you that he got so close, he got such a good look at Daryl Brooks' face that from that witness stand, he'll be able to say to you definitively, Daryl Brooks, the man in orange on the video screen, is the man who was driving the red SUV in this case. You're going to hear from a few more officers. Officer Bryce Butcher and Officer Sonia Schneider. They were positioned at the intersection of Main Street and East Avenue, just a little bit further southwest in that map. You're going to hear them describe how they saw this red SUV approaching. They quickly realized it was not part of the parade. They quickly realized this was a problem. There are people, children, in the street, lining the street. And so they jumped into action. They tried to stop it. As the SUV started barreling towards them, Officer Butcher, again, tried to get in the way. He put himself at risk trying to get in front of the vehicle. Couldn't stop it. Officer Schneider tried to redirect the vehicle up Buckley Street, making a right-hand turn. She'll tell you, and you'll see in the video, there was room. There was space. She couldn't do it. The defendant blew past her. And that's when the screams in the police radio start. You're going to hear from Jim Hawkinson, a battalion chief for the Waukesha Fire Department. He's going to tell you about the massive scope of the emergency response to this tragedy. He was in charge of the fire department that day. He's going to tell you about all of the units that had to respond to the scene, the massive amount of resources needed to triage and treat and transport all the victims. He's going to tell you about the response from other communities in southeast Wisconsin, the mutual aid call that went out, and all the other communities that came to help out. He's going to tell you about how Waukesha Memorial Hospital, just up the hill from the parade route, quickly reached capacity, and so everybody had to be diverted to other medical facilities. We'll transition then into the next chapter of this story, and you're going to hear from some of the people whose lives were forever changed by the defendant's terrible decisions that day. But I'll tell you right now, you're not going to hear from all of them. It wouldn't make sense. It's not necessary. We intend to present the evidence to you in an efficient and streamlined way. We will elicit testimony and introduce exhibits that cover every element of every single criminal charge in this case. But our goal is to avoid duplication of evidence and to avoid undue hardship on the victims and the witnesses who have already suffered so much. So the first witness in this part of the trial that you're going to hear from is Nicole White. She's the very first person, aside from Detective Casey, who was struck by the defendant on that day. She's going to tell you, as we look at this second of the three maps that we're going to repeatedly refer to, that she was marching with her co-workers and friends with Remax. You'll recognize the float, I think, in the videos, because just like the commercials for Remax, there's a giant hot air balloon that shoots fire out of the basket, which is pretty cool. And she's going to tell you she was marching with her friends and her co-workers when, without any warning, she was hit from behind and knocked over. You're going to see video of that. Nicole White has a special significance in this case because, as the first person who was struck, she represents the point in time when Mr. Brooks was legally required to stop. You heard the judge read the hit and run jury instructions, and to summarize, in Wisconsin, anybody who's operating a motor vehicle who's involved in some kind of accident, they have a duty to stop, to investigate, to exchange information. Not only did Daryl Brooks not stop, the evidence will show that he sped up. The evidence will show that as his body count increased, so did his motive to get away. Nicole White, I think, is a good point here for me to explain to you, or to summarize for you, the charge of first-degree recklessly endangering safety. Now, again, the judge read the law to you all morning and a lot of the afternoon, and she's going to read it to you again at the end of the case, and you're going to have a binder with all these instructions written down for you, so you do not need to memorize them, okay? But we're going to talk about first-degree recklessly endangering safety. It's a crime where it's committed by someone who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Let's talk about what the state's not required to prove with recklessly endangering safety. Not required to prove injury. This was a conscious decision in our charging decision. We're not going to get into medical records. We're not going to talk about the details of witnesses' injuries because it's not relevant, except to the extent that it proves that they were endangered and resulted in injury. But we don't need to get into who was hit or how hard or how long they've suffered. We just are going to prove to you that their safety was endangered. So, after Nicole White, we are going to talk, you're going to hear evidence about the first of the larger groups that was affected by this incident, the Waukesha South High School Marching Band. 10 kids in that band got either hit or run over. Here's the first example of our efficient presentation of evidence. You're not going to hear from any one of them. High school-aged kids, there's video showing each and every one of them getting run over. So instead, you're going to hear from their band director, Sarah Waymire Aparicio. She's going to come in and she's going to look at some still shots of the video. She's going to identify each of the 10 kids for you. You're then going to watch and listen to the video, and it'll be clear as day who's getting run over or hit. It'll be clear as day whose safety was endangered by Mr. Brooks that day. As we move further down the parade route, you'll hear evidence about the Burris Logistics Group. You'll hear testimony from Kelly Grabo about how she was marching with that group along with her young daughter. You'll see video of them. They're dressed up like the Who's from Whoville. You'll see them get hit. As we move further down the parade route, you'll hear testimony about the Green family. They're spectators along the parade route. Charles Green is going to come in and talk about how he was there with his family. He was sitting on the southeast corner of Main and Gasper across the street from Martha Merrill's Books. He'll talk about how his kids were seated on a portable bench, something that you bring to a parade to sit on, and how they got knocked off that bench when the defendant ran into them. The next point in the presentation of evidence will involve the Waukesha Blazers. I think it's important to point out you can't consider this evidence of each crime in a vacuum. You need to consider the entire incident. Because at this point, by the time we get to the Blazers, the defendant will have already hit or run over 15 people. You'll see in the video that at this point the defendant has actually increased his speed, and you'll hear from Detective Mike Carpenter with the Waukesha Police Department. He's going to come in and talk about speed analysis. He'll tell you that he's certified to use a software program that basically takes surveillance video, measures the amount of time it takes to travel a certain distance in that video, and calculates an average speed over that distance. And he'll tell you that in video obtained from Bosco's Social Club, which is right in front of where the Blazers got hit, he'll tell you that that video in that area right before the Blazers got hit, the defendant was traveling in excess of 33 miles an hour. There were 5 victims in the Blazers. That includes Jackson Sparks, who was walking with his big brother Tucker. Cut down in the road before he had a chance to put any miles on his soul. Jackson was 8. He died 2 days later in the hospital. I think this is a good point to talk about the law of first-degree intentional homicide. Again, the judge provided the law to you. It'll be provided to you again at the conclusion of the trial. I want you to take a look at that second element. I don't know what the defense in this case is going to be. In fact, the defendant isn't required to put one on at all. He can sit there and not say a word throughout this trial, and that's perfectly within his right, and you can't hold that against him. And in fact, if he does that and we don't prove each and every one of these counts to you beyond a reasonable doubt, you must find him not guilty. That's the law. But if he does choose to present a defense, if he does raise any issues, I expect that he will likely claim that he didn't mean to kill these people. Take a look at that second bullet point. Keep that in mind as you're watching these videos, as you're learning about how this parade unfolded. Consider whether the defendant was aware that his conduct was practically certain to cause the death of another human being. We're going to move further down the parade route, and the next group after the Blazers is the Extreme Dance Group. There were girls of really all ages in this group, from toddlers being pulled in strollers up to high school age teenage dancers. 15 victims, 15 people associated with this group either got hit or were very close to getting hit. That doesn't include 2 additional spectators who were watching the parade from the south side of Main Street near the 5 Points intersection, right in front of the extreme dance team as the defendant drove through. Girls in this dance group suffered catastrophic injuries. The group of victims also includes parents, grandparents, siblings, people marching with the group, but not necessarily as dancers. You're not going to hear from everybody who got hit. You're going to hear from the two instructors, the two young ladies who were tasked with teaching these girls these routines and marching with them and encouraging them and comforting them after the fact. And they're going to, in the video, identify for you where all these girls are positioned, and it'll be very clear the path of travel of the vehicle as it goes through that group of young ladies, who was hit and who was nearly hit. The next group down the parade route is Citizens Bank. And here we reach the second count of intentional homicide. Jane Kulik was marching with Citizens Bank with her friends, with her co-workers. This is the only count of homicide for which there is no clear video depicting how she died. So instead of watching video, you're going to hear evidence from her co-worker and from the man who was driving the truck pulling this float. And they're really the ones who are in the best position to observe exactly what happened to Jane Kulik as the defendant plowed through that parade route. And they're going to describe for you how she was struck, how she was run over. The medical examiner will explain that Jane Kulik's cause of death was multiple blunt force traumatic injuries. We'll move further down southwest along the parade route, and we'll learn about a group that was standing in front of the steaming cup, spectators again. Innocent people have nothing to do with anything. You're going to hear about 3 kids who were standing along with a bunch of others along the curb in front of steaming cup, and as the defendant swerved from the left side of the street as he hit Jane back to the right side of the street as he was avoiding the vehicle that was ahead of him, clipped the curb and hit these 3 kids. Then we're going to move in to the next group in the parade route, which is the dancing grannies. This is the deadliest point in the parade. 7 people in this group were struck. 4 of them died. You're going to hear from witnesses, members of the Dancing Grannies group, who will come in and they will describe being completely caught off guard. They will describe seeing pom-poms in the air, and the next thing they knew, there were bodies on the ground before the pom-poms hit the ground. You will learn about Bill Ospel, who was marching in a support capacity. He was there to support his wife Lola and their friends, the rest of the Dancing Grannies, just walking along the parade route trying to be helpful. And as the defendant swerved around the Dancing Grannies vehicle, which is a white SUV, you'll see it in the video, swerved around the right side, he hits Bill. And the medical examiner is going to tell you that Bill Ospel cause of death was multiple blunt force traumatic injuries. You'll learn about Tamara Durand, marching with the Grannies. This is her first parade. You'll see a diagram of where she was positioned. You'll see video of her getting struck. The medical examiner will tell you that Tamara Durand, cause of death, multiple blunt force traumatic injuries. You'll hear about Lee Owen, another dancing granny, positioned right next to Tamara, who had just begun one of her favorite routines, walking in a winter wonderland, when she got hit. You'll learn about Ginny Sorensen. You'll learn that Ginny was walking at the front of the group carrying the banner. You'll learn that Ginny was normally a coach for the group. Normally she rode in the vehicle in the back so that she could provide feedback and critique to her dance mates. But she filled in at the last moment today and helped carry the banner. You'll see video of Ginny getting struck. The medical examiner will tell you that Ginny Sorensen's cause of death was multiple blunt force traumatic injuries. You'll hear more speed analysis testimony at this point. You're going to hear from Mike Smith with the Wisconsin State Patrol, who's going to testify very similarly to how Detective Carpenter is going to testify about speed analysis. Basically, he takes surveillance video, this time from Curry Insurance, which is on the south side of Main Street. It shows the grannies getting struck. They measure point to point and measure the time between those 2 points and calculate an average speed over that distance, which is roughly from Clinton Street up until the camera cuts out. They'll tell you that at that point, where the defendant crashed through the Dancing Grannies group, he was traveling at approximately 32 miles an hour. The eighth and final group that was struck by the defendant in this case is the Catholic Communities of Waukesha. This is a faith-based organization. It consists of members of multiple local Catholic churches who got together that Sunday afternoon to spread a little Christmas cheer. There is not great video, and perhaps that's for the best, of this group getting struck. In total, there were 19 victims in this group. In what little you can see from the video, you can see the defendant's taillights swerving from the left side of the street to the right. You can see them bouncing up and down. There are no speed bumps in that section of the road. The next phase of the evidence will involve the manhunt. How authorities found the defendant, took him into custody, and the statements he made after he was placed under arrest. You will hear from Officer Bryce Skolton, who was positioned, if you look at this third of the 3 maps I referenced, on the very top of this map at the intersection of Main Street and Wisconsin. Officer Skolton was positioned at that point to direct the parade route to make a left-hand turn from Main Street onto Wisconsin, to stop any traffic coming from the other directions. He saw the defendant come around that corner. He saw the defendant drive right at him as he's standing in the middle of the road. And as the defendant went around him to the left and went south, Officer Skolton fired 3 rounds from his service weapon. All 3 rounds hit the car. None of them hit the defendant. You will hear from another police officer who was not on duty that day. He just happens to be a police officer. His name is Officer Ralph Salyers. He's from the Waukesha Police Department. If you take a look at that map, he's going to describe to you being on the sidewalk, leaving the parade. He was walking past Les Paul Middle School. He's going to describe hearing a loud commotion. He's going to describe seeing a red SUV with just utterly totaled front end damage coming to rest in a driveway at 338 Maple Avenue. You're going to see video of the defendant in the red SUV pulling into the alley behind 338 Maple, and then a few moments later you'll see what appears to be the defendant coming back onto the screen and running away from the vehicle, apparently in a hurry, apparently aware that he had done something terribly wrong. You're going to hear from a series of witnesses between that point and the defendant's arrest, where they will describe the defendant approaching them, contacting them, asking them to use their phone. Because he was in such a rush when he ditched his SUV, he left his phones behind. Then you're going to hear from Daniel Ryder, and I think the evidence will show Daniel Ryder really is a good embodiment of the spirit of Waukesha. Not knowing what Mr. Brooks had done, Daniel Ryder opened his home to the defendant. The defendant showed up at his front door without any shoes on, with a t-shirt, said he was cold, said he needed to use the phone. Daniel Ryder let him inside, gave him a sandwich, let him use the phone, and then gave him a coat. And a few minutes later, the police showed up. You're going to see body cam video of that arrest. You're going to hear from Officer Rebecca Carpenter that she responded to that area around where Daniel Ryder lives because of reports of a man knocking on doors. She takes him into custody. He identifies himself on the body cam video. They search him, and in his pocket they find a key to the red Ford Escape used in this attack. You're going to hear from a series of officers who retraced the defendant's steps that night, recovered surveillance video showing the path that he took, the path that's depicted here in the third map that I'm showing you. You're going to hear how they recovered his sandal, his sweatshirt along the escape route. You're going to hear from Detective Jay Carpenter with the City of Waukesha Police Department, and he's going to talk to you about the defendant's statements after he was taken into custody. I'm going to let that interview speak for itself, other than pointing out for you that you will, I think, quickly learn a few main points about the defendant on the night that this happened. He was lucid. He was aware. He was intelligent. He was probing for information. And he was deceptive. We're going to then wrap up with testimony from people who plugged any of the remaining holes in the investigation. You'll hear from crime lab analysts about DNA evidence, about finding the defendant's DNA on the steering wheel of the red Ford Escape. You're going to hear from Wisconsin State Patrol Inspector Ryan Schultz. He's going to testify about the mechanical inspection that he did on this vehicle. In case you were wondering if there were any issues that would have prevented Mr. Brooks from stopping or from pulling over, he's going to quickly put those concerns to bed. He conducted that mechanical inspection. No problem with the brakes. The accelerator didn't stick. There were no mechanical problems that would have prevented Mr. Brooks from stopping. Finally, we're going to close our presentation of the evidence, not with a witness, but with an experience for you. You are going to go to a secure location, and you're going to have a chance to see the murder weapon with your own eyes. You'll be able to see that red Ford Escape. I want to close now with a few points about how the evidence relates to the law in this case. There are, obviously, we've gone through the 6 counts of first-degree intentional homicide. But in addition to those homicide counts, there are 6 counts of hit and run involving death. Those are separate charges. The evidence will support convictions on all of them, all 12 counts of homicide. But they involve the same 6 victims. Another point I want to bring to your attention is that for each count of first-degree intentional homicide and each count of first-degree recklessly endangering safety, if you find the defendant guilty of any of those counts, you have to answer a second question. Did he commit that crime while using a dangerous weapon? And here the evidence will show that he didn't use a gun or a knife to commit these crimes. He used 3,500 pounds of steel, rubber, and glass. The defendant's also charged with 2 counts of felony bail jumping. You'll hear evidence to support those charges, which includes the fact that the defendant was charged with a felony offense in a case in Milwaukee County and released from custody subject to conditions of bail. And then he was charged with another felony offense in a separate case in Milwaukee County and released from custody subject to conditions of bail. And those conditions of bail included requirements that he not commit any new crime. And those conditions of bail were in effect on November 21st of 2021. We have dozens of video clips to show you. You're going to have notebooks and writing utensils while we present this evidence to you. It's a lot to keep track of. And when you go back into the deliberation room, it might be difficult while you're deliberating to remember which video was about which victim or which incident or which group. And so my suggestion to you is that as we go through these videos, you're free to do whatever you want with your notes, but my suggestion would be as we go through these videos, they each will be labeled with an exhibit number. And so I recommend that you keep track of which exhibit number corresponds with which video. That way, while you're deliberating, if you want to see those videos again, you can ask for them by exhibit number. Can't guarantee that you'll be able to see any or all of them, but you can ask. I'm done now. I want to close on one final point, and that is, on behalf of the state of Wisconsin, I want to say thank you. You're serving in what is the greatest criminal justice system in the history of the world, and that's because of the 16 of you. It's because a group of citizens, randomly selected, come in and make the final, ultimate determination between guilty and not guilty. That's unique in this world. It's special. And so, we're going to go through this evidence. We're going to be mindful of your time. We know how valuable it is. We're going to be efficient, but we have a lot to get through. A lot. And at the conclusion of all that evidence, District Attorney Opper is going to stand up here and she's going to ask you to render verdicts consistent with the evidence, to find the defendant guilty of each and every count. Thank you.
Mr. Brooks, my first question to you is, will you be making an opening statement at this point or deferring until your case? Meaning the defense portion of the case.
I will be deferring at this time, Your Honor. I need a little more adequate time to make sure I go over the points that I need to make.
All right, then the court will honor that request, advise the jury he's deferring his opening statement until a later point in the proceedings. I am going to just take a short break so I can talk some logistics with the parties to determine whether it makes sense to start with a witness tonight yet. It's 4 o'clock, a little bit after, or wait until tomorrow. So either way, you'll come back because you'll either hear testimony or I'll read an instruction for you. But at this point, the jury may be excused. Thank you. Be seated. Attorney Opper, your first witness, how long would that witness be?
Our first witness is Sergeant Warner. I expect his testimony to take 10 to 15 minutes on direct. I would ask that you would hear his testimony this evening, or this afternoon, Your Honor. He was supposed to have left town at about noon today to take his daughter on a college visit in Kentucky. He's delayed his departure so he could provide his testimony. And if we can get him in and out, he will leave at 5 o'clock and arrive at midnight at his destination. I have a second witness, if the court would hear me, who's here as well. Her testimony probably would also take about 15 minutes on direct, maybe a little longer. No? Mr. Mitchell says no. She has traveled here from Janesville. Her transportation is also difficult, and so she's here and ready to go if the court would indulge those two witnesses this afternoon.
It certainly seems reasonable. Mr. Brooks, my question to you then is, do you want to come back over for the testimony of those witnesses?
I would prefer to. I'm still kind of taken aback by not being able to know exactly how many witnesses are expected to testify. and not being able to turn in my own witness list.
Well, Mr. Brooks, you've been given copies of the witness list. The state's offered you a flash drive with all of the exhibits to streamline what will be presented at trial versus what is in discovery, so you've had ample opportunity to review those. I'm happy to bring you back. I need you to pledge to me that you will follow the rules of procedure and evidence, that you will only interrupt if you have an objection. That objection needs to be founded in law. And then you need to pledge to me that you will honor whatever decision I make so that the testimony of these individuals can proceed within the time frame that the prosecution has indicated it will take. You, of course, will have an opportunity to cross-examine them. Are you willing to follow the rules of courtesy and decorum and the rules of procedure and evidence?
From what you explained yesterday, the objections you said have to be like, I think you said like 3 words. Is the way to actually object. So I don't recall you.
I can give you up to a sentence. What I am trying to avoid, sir, are what are called speaking objections. The idea behind that is that you give me just a little bit of information so that I can either make a determination or, if appropriate, send the jury back out so that I can then hear arguments from the parties. Some objections really are one word, hearsay, maybe 3 words, calls for speculation, things of that nature. So if you're willing to abide by that procedure, then you can come back to this courtroom.
I can't really definitively give an answer right now to that.
So you're not willing to follow the rules of courtesy and decorum and procedure and evidence?
That's not what I said.
That's why I'm asking the clarification question, sir.
I was clear in what I said. I don't think I can make that determination right now.
Let me ask it this way, sir. You may reclaim your right to be present if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. Are you able to do that, sir?
I thought I have.
Sir, it's I think, a fairly simple question. I'm asking you if you are willing to conduct yourself appropriately. I'll shorten it to that. Are you willing to conduct yourself appropriately, sir?
I have, to the best of my ability.
Sir, please answer my question directly. Are you willing to conduct yourself appropriately?
I have conducted myself appropriately.
I'm not asking about your past behavior. I'm asking if you're willing from this point forward, for the purposes of the testimony of 2 witnesses, to conduct yourself appropriately.
I have.
That's not my question. That's not the answer I'm looking for. I'm not asking if you have. I'm asking if you're willing going forward to conduct yourself appropriately during the questioning of these 2 witnesses. Yes or no?
I'm going to end up getting put back over here eventually if I come over there.
Mr. Brooks, I'm further advising you, I'm looking for a direct answer of yes or no, and that your failure to give me a yes or no answer will be considered by this court to be non-responsive. So let me ask you the question one more time. Are you willing to conduct yourself appropriately during the questioning of these 2 witnesses?
To be 100% honest, I cannot answer that.
All right, then based on that answer, which is non-responsive to the question that I asked, he has not given me a pledge or indication of a willingness to conduct himself appropriately going forward, and based on that, he'll remain where he is. You will remain unmuted, and so if you have an objection, you can lodge that objection within accordance or according to the rules of evidence, sir. All right, with that, let's have the jurors brought back in, and we'll start with the taking of testimony.
One quick second to put this up, then you're on.
Go ahead.
Thank you. I don't think it'll take long if you want to call for him. I did the call.
Let's,
Non-responsive.
you did not answer yes or no.
Yeah, I didn't put on.
All right, do we need to
So
back
that's
out?
taken as being non-responsive.
Do I need, I wanted to see if the camera angle, so have them wait for a sec, please.
Sorry.
Excuse me, Your Honor.
I'm not going to answer any other questions at this point. The state's setting up a map for use with a witness. I want to make sure that it's something that is viewable on the witness camera that is being transmitted into the courtroom where you are seated. So let me back up.
The whole thing.
Let me back up, zoom out a bit. Attorney Opper, you want to look at the screen above and tell me if you think that accurately depicts what you're going to go over on that map? Do I need to back out a little bit?
Just a little, yeah, because the top of my hand's not showing here. Just a little.
Hold on. I'll go up.
Can I say something for the record?
Do you think with where that chair is, the witness will
I
be?
would ask the witnesses to have to stand where I am so that everybody can see.
Oh, that would be a good idea.
Okay.
No, you're not muted yet. Mr. Brooks, if you're asking me to make a judicial determination, I've already rendered a decision about where you're going to be.
Because I didn't answer your question the way you wanted to.
All right, I'm going to mute you, sir. Now we're moving on to that part of the procedure since you are you're not following the protocol that I've set in place, that you are back to one of these sovereign tactics about, have I made a judicial determination? The record speaks for itself, sir. I'm not going to make a further record on that, nor will I answer the question about, am I making a judicial determination? I've made a decision, and that decision is you will remain in the other courtroom. Once the jury is brought back in, I will unmute so that you can lodge objections, but if you interrupt without making an objection and just start talking about a judicial determination, then I'm going to mute you once again, and the procedure for objecting will require that you raise your sign, write it out, and provide it to the bailiff, who will provide it to the court so that I can rule on it. If that slows things down, then so be it, but that's the procedure that I'm going to follow. All right, the jurors can be brought in then. As a reminder, I'm not requiring an all rise even for the jurors. I understand you may do it, but there's a reason why I'm not requiring it, so. Mike, will Pete have the notebooks?
Yeah, I'm ready.
Oh, excellent. Thank you. You can start passing them out. Ladies and gentlemen, you may have a seat, and the writing materials will be passed out. Our intent is to have the state call its first two witnesses. And then once that is done, I have an instruction to read, and then we'll break for the day, and I'll consult with the parties before I let you know what time you should report tomorrow. And keep in mind, my time I say we start for court might be different than your report time. All right. All the materials passed out? Very well. Then the state may call its first witness.
Thank you, Judge. State call Sergeant Dave Warner.
Good afternoon, Sergeant. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat, at least initially, or do you want him to stay standing?
No, actually, you can start out seated, please.
Very well. Sir, would you please state your first and last names for the record and spell each?
Yes. My name is Sergeant David, D-A-V-I-D, Warner, W-A-N-N-E-R.
Thank you. Go ahead, Attorney Opper, your witness.
Thank you. Sir, how are you employed?
I'm a patrol sergeant with the City of Waukesha Police Department.
How long have you worked in law enforcement?
18 years.
And as patrol sergeant, what are your general duties and responsibilities?
I oversee officers across all shifts that are assigned to the patrol division.
Want to direct your attention to the date of November 21, 2021. Did you work that day?
Yes.
Were there any events occurring in the city of Waukesha that afternoon?
The Waukesha Christmas Parade was that afternoon.
Has the Christmas parade been held in years prior to 2021?
Yes, every year that I've been employed at the police department, we've had a Christmas parade.
And is it typically that third week in November before Thanksgiving?
Yes, every year that I can remember it has been.
Okay. Is there any planning or preparation that goes into holding a parade in Waukesha?
Yes, there are meetings with the group that's putting on the parade in advance. There's also a group of individuals that prior to the parade, usually the Friday before, will post no parking signs along the parade route. There's a group from our city garage or Department of Public Works that'll put out barricades at the designated intersections where we request them to put them out.
And what about manpower? What type of manpower would you devote to an event like this, sir?
It's rather significant given the large area that a parade like this encompasses, the estimated amount of attendance at the parade between detectives, police officers, supervisors, reserve officers, community service officers. I would say we have in excess of 30 additional bodies planned that day just to handle the parade itself.
You mentioned the use of individuals such as reserve officers and community service officers, I think you said. Is that correct?
Yes.
Are those sworn law enforcement officers?
They are not sworn, no.
What is their role or function?
The reserve officer group is a group of people who volunteer their time to help with events like parades. They're given training in directing traffic and closing streets down. A community service officer is a paid position. They're part-time employees, usually younger individuals learning or looking to learn more about a career in law enforcement.
And you said also parking attendants would be assisting in this endeavor?
Correct. We're usually looking to get as many extra bodies as we can, and the assistance from our parking agents is usually required for this event as well.
And this would be in addition to the sworn law enforcement officers that are assigned to work the parade?
Correct.
And obviously you still need other officers to patrol the city, correct?
Yes.
Where is the parade held?
The parade takes up a large portion of our downtown area. There's a staging area that the floats before the parade that they're all instructed to assemble in a particular area along White Rock Avenue between Niagara Street and Main Street. And that's about a 3-hour process of getting all the parade participants into that area and lined up accordingly. The parade itself runs along Main Street from White Rock westbound to the Veterans Park area, where it makes a turn and then heads up Wisconsin Avenue and ends near the Waukesha Public Library.
Sir, if I could ask you to stand up and refer to the diagram behind you. This is a map that's been marked as State's Exhibit number 1. Do you see that sticker in the bottom right-hand corner?
Yes.
Okay, I'm sorry, it's a little tight up there.
Sorry.
But if you could start in the upper right-hand corner of the map, and Your Honor, if we put up the digital copy of the map as well, I know it's hard to see, but then we'd have to do the screen share again. Is that correct?
Yes, it's my understanding.
Okay, I'm gonna ask the paralegal to please put up State's Exhibit number 1 on the digital copy as well. Is that ready? No. Sorry, we got the wrong one. All right, Madam Clerk, thank you. We're ready here.
As you present that, you know you can hit that little arrow, that will get rid of those extra things that aren't needed. There you go. Go ahead.
All right, and Ms. Gussie, if you could zoom in on the upper right-hand corner, please. There you go. All right, sir, if you can use the map, the big map in front of you, please, and the jury can follow along with the digital copy if they want. So starting in the upper right-hand corner. Yes. What's up there, please?
That is Frame Park.
And what's at Frame Park?
Frame Park has a lot of, it's got a playground for children, there's a very large baseball diamond, different shelters, there's a formal garden, there's a boat launch. It's a very large park in our city that encompasses a lot of different activities.
Is the boat launch shown on Exhibit 1?
Yes, right here.
Okay. And the waterway that's shown on the exhibit, what is that waterway?
That is the Fox River.
Now, is the parade route shown on Exhibit 1?
Sorry, Attorney Upper, can you give me 1 second? Mr. Brooks, just a reminder, you're not muted.
Oh,
All right, I'm sorry for the interruption. Go ahead.
I'm sorry too. I thought I was muted. I apologize.
That's okay. Thank you so much.
Go ahead and point out the parade route, please.
So the parade route in this map is essentially this purple line. This area here is what I referred to earlier as a staging area. And then actually at this corner right here, westbound is where the parade route would follow down to the corner here. I refer to this as Veterans Park. That's that area there. And then it would turn up Wisconsin Avenue and end around the library right here, which is that green area.
Okay, and we're just putting that up on the digital display too right now. Now, on this map, sir, we've designated several points along the parade route to reflect where various officers were positioned. Is that correct?
Yes.
And could you just briefly walk us through it? I don't need you to name every officer, but just point out the intersections and what was located at each intersection using Exhibit 1.
Sure. I was here at the intersection of Hartwell and White Rock. I had a police SUV, an unmarked police vehicle, trying to maintain the integrity of the route and keeping the road shut down. Here we had various officers. It's kind of a mixed use of barricades, marked police vehicles, police tape, just in an order to keep the streets shut down and make sure that there's a visible representation that the streets are not open.
Please keep going down, westbound down Main Street, please.
Sure. So we come to Buckley and East Avenue here. Both sides of the intersection shut down with barricades. We come down further on West Main Street to Martin Street. The red line here signifies a barricade was in place there. At Main Street and North Barstow Street, again, barricades on both sides of the intersection there. Gaspar and East Main Street, a barricade. We also had a marked police fleet, as we did at other places where the yellow is signifying that. This is our 5 points area, as we call it, kind of a larger intersection with roads in different directions here. So at this intersection, we had a use of barricades, police tape, police vehicles. It's just a very large intersection to be able to shut down just with one of those things. So it kind of becomes a mixed use of different tools that are available to us. We have Clinton Street and Main Street here. Again, barricades on both sides of the intersections, along with officers. Maple Avenue and East Main Street, barricades and reserve officers. And then we come around toward the Veterans Park area, again, another very large intersection where we had an officer and multiple barricades shutting off the traffic. And then along Wisconsin Avenue here, we had one point at Maple Avenue where we had a CSO along with a barricade.
And right now you're pointing at the very bottom edge of the map, correct?
Very bottom here.
Okay.
And then from that point east, the parade kind of disassembles with floats going different ways depending upon their size and maneuverability at the end of the parade route.
This map, exhibit number 1, is oriented north, correct?
Yes.
Okay. The items, and I know this is like a vision test for everybody, but on the map, the yellow boxes represent what, please?
The yellow boxes on this map represent police vehicles that were utilized in the parade.
Okay, and what about the blue boxes?
The blue boxes are the names of personnel assigned. Where you see an RO, that would be a reserve officer, PA would be a parking agent, CSO would be our community service officer, OFC would be an officer.
All right. The reserve officers and non-sworn officers, would they be wearing a police uniform or some type of designation?
Yes, they all have.
Hold on. There's an objection. It's overruled. He may answer.
All personnel on the parade route are in uniforms. Additionally, everyone, it's part of our policy that they are required to wear traffic vests, which would have been a yellow and could have been blue and yellow or orange and yellow traffic vest that says police on it.
Okay. I'd like to go back to the area on White Rock where you were located, where the units were staging, correct?
Yes.
Now, can you describe for us where the road was actually shut off by police so that no motorist could actually travel down the road?
Sure. I mean, this actually further north than here, it's off the map, is where we had our first point of shutdown. It was at White Rock Avenue and Niagara Street. We used Niagara Street to divert any traffic that would have come that direction. So then along here, there would have been shut down at Niagara. There's another street called Perkins where it was shut down. And then right here is Baxter Street, where we had the street shut down. Additionally, here along the staging route, North Hartwell Avenue here was shut down on both sides of it to ensure no traffic entered into the staging area while that space was occupied.
All right, and before I have you sit down, there's two other areas designated on the map I'd like to ask you about. This is on the left, upper left quadrant of the map. On the north side of the Fox River, there's something indicated as the Barstow Hill. Do you see that on the map, sir?
Yes, right here by the green line.
What's the Barstow Hill?
The Barstow Hill is just a very steep hill that more or less connects our downtown to a neighborhood and is a thoroughfare of traffic coming and going from the downtown area.
Okay, that's Barstow Road there?
Correct.
Okay. And then, just to the right of that, there's something marked as a mobile gas station, is that correct?
Yes.
Objection.
Overruled.
And, there is a gas station at that intersection, sir?
Yes, there is a mobile gas station at the bottom of the Barstow Hill.
Okay. All right, please have a seat, sir. Sending officers out to their locations along the route here.
At 1 p.m. is when the initial few officers head out to secure the staging area. So they're out there from 1 o'clock until about 3:30. Between 3 and 3:30 is when the rest of the personnel assigned to the parade would have arrived at their locations along the route.
All right. And I assume you're in some, Your Honor, we just lost part of the Polycom.
Well, we'll pause. See what happened otherwise.
And we can take that down for now. We don't need the state's table displayed at the moment.
Mr. Brooks, we lost you for a second. As soon as we knew it was down, we stopped. We didn't take any additional testimony. I just want to confirm you can see and hear me.
Yeah, I can hear.
And you can see the 4 cameras, so the witness as well?
Yeah.
All right, thank you.
Okay, so, there's somebody that's running the parade as far as lining up the participants and making sure everybody that's walking in the parade is where they're supposed to be, correct?
Correct.
Is there a title for that person?
Boy, I wouldn't know.
Your objection's noted, it's overruled. He may testify about the question asked.
Or is there somebody that you were dealing with directly that was kind of responsible for the units of the parade and you're responsible for the security of the parade?
Yes, there was
Overruled, he may answer.
There is a lady from the Chamber of Commerce who put on the parade that just prior to the parade starting, I had a face-to-face contact with to inform her that the route was ready for the parade.
Now, how do you know that? How do you know that the route was ready to go?
Between 3:30 and 4 o'clock, I had driven the route several times within the parade route on the street that was shut down. It was my duty as the incident commander of the parade to make sure that the officers or personnel assigned to the parade were all in their location, that all the barricades were in place, that there was no holes in the parade route that we missed in the planning, and as a final security sweep of the route just to ensure everything was in place as we had planned for it to be.
Can you estimate how many spectators were present?
Objection.
At what time?
I'm sorry, at the start of the parade.
Thousands. Once the parade had started, I was not on the route anymore. I think the last time I drove the route itself would have been just before 4 o'clock as my final lap through.
Okay. And there's spectators on both sides of the road, north and south sides of Main Street?
Correct.
And all the way from Hartwell all the way down to Veterans Park at the end there near Wisconsin Avenue?
Yes, I'd say the majority of this.
Hold on, there's been an objection. Go ahead, what's your objection?
That is hearsay. We can't know for sure where everybody was at.
The objection is noted. It is overruled based upon the foundation previously laid by the witness. Go ahead.
The spectators are primarily from the intersection of White Rock and Main Street westbound.
So you were satisfied it was appropriately safe to start the parade, is that right, sir?
Yes.
What did you do?
I had face-to-face contact with the organizer of the parade. I indicated to her that I checked the route and from the police side of things that we were ready for the parade to proceed, and let her know that she could begin whenever she was ready.
About what time of day was that?
It was right about 4 p.m.
And you had mentioned the units were staging on White Rock near where you were posted, is that right?
Yes.
And did you see, as the units would enter the parade route, then they all kind of move forward, I'm assuming?
Yes,
Overruled.
the parade participants are set up on either side of White Rock Avenue, and they're kind of funneled together into almost a zipper type fashion as they enter the parade route.
And as they march forward towards the parade route, then at some point is the road behind them vacant?
Correct.
And what do you do when that happens?
We try to cause as little disruption in the city. Shutting down White Rock Avenue, it's a very major thoroughfare in the city, and having it shut down for that extended period of time causes some pretty significant traffic problems. So as the road is no longer occupied by parade participants, we try to open up the road from behind them, keeping the back of the parade shut down, always taking into account a street for a car to turn off onto. So
Did you remain in that same position near White Rock and Hartwell?
yes.
And do you remember how you had your squad positioned?
Objection, that's hearsay.
Overruled.
I had my squad positioned across White Rock Avenue in an east-west fashion, essentially in the middle of the roadway. The road is much wider than the SUV squad I was driving is. I positioned it that way to give a visual representation to motorists that the road wasn't open.
And is your squad marked or unmarked?
It is unmarked.
Objection, irrelevant.
It's relevant. The answer may stand. Make sure if you hear an objection, sir, that you wait till I rule on it too. Thank you.
Are there red and blue lights on your squad car, sir?
Yes.
Objection, irrelevant.
Overruled. The answer may stand.
Did you have your red and blue lights activated as it was parked across the roadway?
Objection, irrelevant.
Overruled.
Yes.
You remember hearing something about a disturbance near the boat launch?
Yes.
Objection, hearsay.
Are you offering it for the?
Foundational, Your Honor.
Or it's not being offered for the truth of the matter asserted. The objection is overruled. He may answer. I believe he answered yes, and it may stand.
All right. What do you remember hearing about an incident at the boat launch?
When I was near my position on Hartwell and White Rock, I was speaking with one of our reserve officers. We were discussing the proper timing of the opening of the road. And I overheard actually on his police radio that he was wearing squads that were not assigned to the parade being sent to a fight at Frame Park that involved knives.
Were you aware of any vehicles being associated with that fight?
Objection, irrelevant.
Overruled. He may answer.
I did not hear of any vehicles associated.
What do you remember next, sir?
I remember seeing and hearing squads responding to this this fight at Frame Park, and at that time we were still focused on opening up the roadway, and I made my way back toward my unmarked police vehicle, and I looked to my right or to the north down White Rock Avenue, and I saw a red SUV traveling toward me at a high rate of speed.
What do you mean by a high rate of speed, sir?
Objection, that's hearsay.
Overruled. He may answer.
I believe the vehicle is traveling in excess of 40 miles per hour.
What's the posted speed limit there on White Rock Avenue?
It's a 25-mile-per-hour zone.
What about Main Street in downtown Waukesha? What's the posted speed limit there, sir?
The speed limit.
Irrelevant.
Overruled. It's relevant.
The speed limit throughout the parade route is 25 miles per hour.
What did you do when you saw this red SUV traveling at a high rate of speed?
Objection, leading the witness.
The objection is noted. It's overruled.
When I saw the red SUV traveling toward me at a high rate of speed, I used both hands and waved them overhead like this in an attempt to catch the attention of the driver.
Were you dressed in a police uniform, sir?
Yes.
Let me
And-
just put on the record when the witness, so that's clear, placed both hands over his head in what I would describe as a waving kind of back and forth at a diagonal gesture. Thank you. Go ahead.
Did the car continue in your direction, or the SUV?
Yes, it did.
What did you observe the path of travel for the SUV to be?
Objection, that's hearsay.
Mr. Brooks, it's not hearsay. Your objection is overruled. You may answer.
Could you state the question one more time?
Sure, where did you see the SUV go? Better question.
Objection, irrelevant.
Overruled.
The SUV entered the parade route.
I want you to describe what you remember seeing as it passed your location, please.
As I was waving my hands overhead, I was approximately 6 feet from where the SUV was driving. As the driver passed essentially in front of me by about 6 feet, I could see the operator of the vehicle and just a dazed, straight, focused look straight ahead, not looking at anyone.
Did the driver appear to respond to your efforts to stop the vehicle?
There was absolutely no response.
Did you notice the car slow down in any fashion?
No, in fact,
Hearsay.
It's not hearsay. It's overruled. He may answer.
as the SUV passed me, I looked over the hood of, or the top of the police vehicle that I had positioned on the road there, fully expecting that as it passed that I would see the car slam on its brakes as it realized it had entered the parade route, figuring it was a lost motorist. I didn't see that happen. It continued into the parade route at a high rate of speed.
What did you do?
Upon seeing that, I got on my radio in an attempt to notify other personnel assigned to the parade route. I stated that a red SUV had just blown by me.
Do you remember using those exact words, sir?
Objection, that's irrelevant.
Overruled. He may answer.
I don't know if I said a red or maroon SUV, but I remember saying that it had blown by me.
Were there parade units still on White Rock attempting to get onto the parade route at that point?
Yes.
Objection.
Were you able to see the vehicle clearly as it
Hold on,
went?
he
I'm sorry.
objected. It's overruled. Go ahead.
From where you were standing there, were you able to turn and watch the SUV as it traveled past you down White Rock towards Main Street?
Objection.
Overruled.
Just asked that.
I only watched it for a short period of time before returning to my squad car, knowing that some sort of police action was going to need to be taken.
What did you do once you got to your squad?
I got in my squad car and was bombarded with the most terrible Is the most terrible thing I ever heard.
The sounds. Yes. You didn't see anything at that point as far as people getting hit?
No.
Okay. I want to show you a video clip, sir. This is State's Exhibit number 2. Madam Clerk, if you could please turn on the State's table. Yep, I'll tell you. Okay?
Just show it to the witness.
I'll show it to you first. So, Sergeant Warner, if you look at the screen in front of you, we're going to play a video clip. It's pretty short in duration. I want you to watch it first before we show it to the jury. I'm going to ask you some questions, okay?
Okay.
Did you see that clip, sir?
Yes.
Is that a video clip you've seen before?
I have seen that, yes.
Okay. Do you believe that's a true and accurate representation of the SUV traveling on White Rock Avenue near the start of the parade at Main Street?
Yes.
Move for admission and permission to publish, Your Honor.
Any objection, Mr. Brooks?
Can you repeat that? I'm sorry.
The state just moved admission of Exhibit 2.
No, I object to that. Keep it.
All right, the objection's noted, it's overruled. Exhibit 2, ladies and gentlemen of the jury, is received. Permission to publish is granted.
Thank you. Please hit play. Sergeant Warner, is that consistent with the vehicle you saw traveling away from you past the parade floats that were about to enter the route?
Yes.
And is that consistent with the approximate speed you saw it traveling?
Yes.
After you became aware that something terrible was happening on the parade route, your incident commander, what do you do?
I drove in my police vehicle down toward the area that I just heard repeated over and over on the radio where the casualties had taken place, and that would have been at Main and Gaspar. And once I got to that position, I parked my vehicle as it was impossible to drive any further.
Was there a call made for assistance?
Yes, I don't know who said it, but an officer used a code over the police radio basically requesting police assistance from any officer in the county that would be listening.
Did multiple officers respond
Yes.
from within Waukesha County?
From when,
The objection irrelevant.
Overruled.
Waukesha County and far beyond.
Thank you, sir. I don't have any other questions at this time.
Mr. Brooks, do you have any questions for this witness?
Yes, I do. Good afternoon, officer. First off,
Good afternoon.
I'll say this is very emotional, so I'm gonna try my best not to keep you up there any longer than you would like to be. My first question is, I noticed that you are in uniform today. Is it fair to say that if you weren't here testifying that you would have been on duty today? Is it fair to ask that or say that?
Not have been at work today.
So did you feel the testimony that you would be given at trial today warranted you to be in uniform?
Objection, relevance, Your Honor.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
You said you've been in duty for 18 years, correct?
Yes.
In any of those 18 years, have you ever come across or had any interaction with the plaintiff in this matter?
Objection, vague.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
How long have you known the plaintiff?
Objection, vague and irrelevant.
Sustained. You do not need to answer that, sir. Next question, Mr. Brooks.
Do you see the plaintiff in court today?
Objection, vague and irrelevant.
Sustained. Next question.
Do you have any knowledge of the plaintiff?
Objection,
Sustained.
Have you ever even seen the plaintiff in this matter?
same objection.
Sustained.
I want to go to the clip that was just shown.
Would you like it shown to the witness again and published to the jury?
I'm sure would he prefer for it to be so again?
I just wanted to know if that's what you were asking. You can certainly question him about it, and if need be, it can be shown again.
Okay, can you show the witness the video clip again?
Sure. All right, I can tell from my monitor and the witness monitor it is up, but it's not being projected to the courtroom other than that. And you can go ahead and play it. All right, your question, sir.
In that clip, is it fair to say that you can see that there are people walking in the street and on the sidewalk? Would that be fair to say?
Yes, I could see that in the video clip.
Do you see anybody being targeted or being in a panic to get away from the vehicle?
No.
Do you see the said driver of that vehicle intentionally trying to hit anyone in that video?
No.
So again, I would ask, were you brought here today to testify on behalf of the plaintiff?
Objection, asked and answered.
Sustained. He already answered that he was why he's here.
Again, I would ask just one more time for the record. Do you see the plaintiff in court today?
Objection,
Sustained. Do you have any other questions, Mr. Brooks?
Do you know of the plaintiff at all whatsoever?
objection.
Sustained.
No further questions.
All right, thank you. Any redirect?
No.
All right, thank you, Sergeant. You may step down. Is he released from his subpoena?
Yes, please.
All right, thank you. He's released.
Really quick on the record, if I may.
We're going to call the next witness. Do you have we have the jury in the courtroom. Do you have a question, sir?
I will have a oral tennis motion I would like to be put on the record.
If you have a motion, you'll have to wait until after the next witness is called. Write it down, submit it on paper, and I'll review whether it's appropriate for this court to address. All right, the state may call the next witness.
The state calls Corey Runkle.
All right. Good afternoon, Ms. Runkle. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, will swear you in. Is the map to stay up at this point?
It doesn't need to, but it also doesn't need to come down, I don't think.
How about I
It's in the
just,
way.
use, over here, we'll just put it behind.
Okay.
Just stick it behind. The easel can stay there. All right, and my clerk Teresa's over here. If you would raise your right hand, she'll swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I solemnly swear.
Thank you, ma'am. Please have a seat. We'll get that settled, and then the first thing I will ask you to do, excuse me, is to state and spell your first and last names for the record.
My name is Corey Runkle, and it's spelled K-O-R-I-R-U-N-K-E-L.
Thank you. Go ahead, your witness.
Thank you. Good afternoon, Mr. Runkle. Do you know a person named Erica Patterson?
Yes,
How do you know that person?
from the shelter,
What shelter are you talking about?
women's shelter,
What city is the women's shelter in?
Waukesha.
And when did you meet Erica Patterson?
Around probably October, I think.
Okay. You are not used to testifying in court, right?
Not really.
I'm going to ask you to scoot a little bit forward. The nice lady in front of you is.
Microphone a little bit, a little closer. I think that'll help. Thank
We just
you.
have to make sure that everybody can hear, especially the court reporter in front of you, because she's writing everything down. Okay.
Okay.
So can you answer, when did you meet Erica Patterson?
Either October or November.
Of what year?
21 this year.
2021.
Yeah.
Okay. Did you meet her at the women's shelter that you're
Yeah.
talking about? Okay. What was your living arrangements at the shelter?
Okay, it wasn't this year. It was last year, I think.
2021.
Yeah.
Okay. And what were your living arrangements at the women's shelter?
We were bunking together.
You and Erica?
Yeah.
Okay. While you were bunking together with Erica at the women's shelter, did Erica ever talk about a boyfriend of hers?
It wasn't her boyfriend.
Okay. Did she ever talk about a man?
Yeah.
And did she ever provide the name of that man?
Yeah.
What was it?
Daryl Brooks.
Okay. Were you with Erica on the afternoon of November 21st, 2021?
Yes, until I split up with her.
Okay. Can you tell us where you were with Erica before you split up with her?
I forgot what park it was, but we were at like the park where the dragonfly was, except for we were at the docks.
Is that in Waukesha?
Yeah.
Okay. And the docks, are you talking about a river?
Yeah.
So the park by the river?
Yeah.
Okay. What were you doing with Erica in the park?
Hanging out.
Okay. Was anybody with you?
Yeah. Kyle.
Okay. And you mentioned that you split up with Erica at some point, is that right?
Yeah.
Do you remember why?
To go hang out with Nick.
Do you know Nick's last name?
Kirby?
Okay. And Erica didn't go with you?
No.
Okay. So what happened after you split up with Erica?
She met up with Daryl.
How do you know that?
Because she was on the phone with him and they said that they were going to meet up.
Now, before that day, November 21st, had you ever met Daryl Brooks?
No.
You'd only heard his name from Erica?
Yeah.
Okay. After you split up with Erica and she went to hang out with Daryl, did Erica ever contact you or Nick after that point?
Yeah.
How did that contact take place? Did she see you or did she call you? How
No,
did that
she
happen?
called me on my cell phone.
Okay. And what was the nature of that conversation?
That he was beating her up and he was following her.
Okay. What did you do when you learned this information from Erica?
Me and Nick started running to where she told us she was,
Where was that?
by the school. I
Okay.
forgot what school it was, but it was by the school.
All right. Did you find her?
Yeah.
Do you remember where you found her?
Right in front of the school.
Okay. Do you remember what was happening when you found her?
He was swerving into her.
When you say he, who are you talking
Oh,
about?
Daryl.
Daryl, the person?
Yeah.
Okay. Did you hear Daryl saying anything to Erica at that time?
He was yelling at her to get back in the car.
Okay. Did she?
No. She tried, but I pulled her away.
Okay. Before you testified today, you reviewed a couple of surveillance videos, is that right?
Yeah. No, not today, but a while ago.
A while ago, not
Yeah.
today. I'd like to put Exhibit 3 up on the screen for the witness for identification.
Go ahead.
So, Ms. Runkle, we're going to play a few moments from this video. I want you to watch and see if it's the same video that you've reviewed previously. Okay, so we're just going to play about 10 seconds here.
I could just tell that's her walking up.
Okay, let's pause there. So you viewed this video. Is it an accurate depiction of how the events unfolded in front of the school you're talking about?
Yeah.
I'd move Exhibit 3 into evidence and ask to publish.
Any objection, Mr. Brooks?
Yeah, my objection would be, you've only played 5 seconds of the video, whereas the other 5, you just said 10 seconds that you would play. I'm curious to see the rest of the video.
Your objection is noted, it's overruled. This is for foundation to establish it's what the witness is going to testify about. She's testified, it's a fair and accurate depiction of what the events that unfolded in her presence, and I will receive Exhibit 3. Permission to publish is granted.
All right, we're going to hit play from the beginning.
There's his car.
Let's hit a pause.
Okay.
Let's hit pause. We're at 16 seconds. We saw a person wearing a blue shirt walking from the left. Do you know who that person is?
Erica.
Erica Patterson.
Yeah.
And when you said, there's his car, what car were you referring to?
The red one. The
And
SUV.
do you know who was driving that car?
Daryl.
Daryl Brooks?
Yeah.
Okay. And again, this would have been the first time you ever saw Daryl Brooks, is that
Yeah.
correct? Okay. We're going to resume from that point, but wait until I pause again to speak again, okay?
I'm sorry.
That's okay. So we'll play from 16 seconds. Let's pause there. Paused at 2 minutes and 44 seconds. During that clip, we saw a red SUV towards the top of the screen. Is that right?
Yeah.
And did you recognize that vehicle?
Yeah, that was Daryl's.
Okay. Yeah. We see now at this stoppage point, we can see two people on the upper right-hand corner. Do you know who those people are?
Me and Nick.
Do you know which one you are?
The one with the green gloves.
So left or right?
I think
As we're
the
looking.
one up in front.
And then there's a person with a white hood. Do you know
Yeah,
who that is?
that's Nick.
Okay, so you're the other one on the left?
Yeah,
All right. And you saw Erica?
yeah.
All right, let's resume playing at 2 minutes and 44 seconds. Let's pause there. Pause to 3 minutes and 19 seconds. Who's the person in the gray hooded sweatshirt?
That's Daryl.
The objection's overruled. For answer may stand.
That's Daryl.
How far away would you say your face was from Daryl's face at this point in the video?
I was chesting up.
Chesting up?
Yeah.
So I guess that's pretty self-explanatory. Do you see Daryl Brooks either in the courtroom or on any monitors in the courtroom right now?
Yeah.
Your Honor, and actually for this point I would ask that the court order the defendant to remove his mask.
Mr. Brooks, you're ordered to remove your mask.
No, I'm not gonna do that.
Mr. Brooks, we talked about this at a prior hearing. For purposes of identification, you're ordered to unmask. Thank you, sir.
So now I'll re-ask that question. Mr. Runkle, do you see Daryl, the person you're talking about in the video, either in the courtroom or on a monitor in the courtroom?
Yes.
Can you tell us where?
In orange?
On the monitor in front of you?
Yeah.
I'd ask the record to reflect that the witness has identified the defendant.
The record will so reflect. Thank you, Mr. Brooks. You can remask.
Let's hit play and resume at 3 minutes and 19 seconds. All right, we've reached the end. Ms. Runkle, can you tell us what was happening in that last portion of the video we just watched?
Well, before Erica, me, and Nick showed up in the camera, that's when I ran after Erica from getting ran over, and then she tried to jump in the car with him, and then I ended up chesting up to him, and then we ended up going at it. So yeah.
How would you describe the level of your volume during that interaction?
Like, what do you mean?
Were you yelling?
I'd say yeah.
Was Mr. Brooks yelling?
Yeah.
Was anybody else in that video, either Nick or Erica, were they yelling?
Erica was telling me to stop.
Okay. And what happened after the physical confrontation with Mr. Brooks?
Nick pulled me away,
And then what happened?
and then Brooks walked off
Did you see where he went?
into his car.
The red SUV in the video we
Yeah.
just watched? Was there anybody else in the SUV at that point that you saw?
No.
And what happened next?
After that, it was like he headed out.
Okay. Did Mr. Brooks say anything to you or Erica or Nick as he was leaving?
He told Erica he was. Oh,
The basis for your objection, you said objection, right?
Is hearsay and irrelevant.
Is it being offered for the truth of the matter asserted? From the
Well, it's
state?
a statement by a party opponent, so it's not hearsay.
Oh, it's his statement, sorry. I think I misheard what she said. All right. The objection is overruled. If it's, she may testify as to words that you spoke on this occasion. Go ahead.
he told Erica that he was gonna find her and he was gonna kill her.
Can we pull up Exhibit 5 for the witness, please? While we're waiting on that, did you at any point come into contact with police or a police officer after Mr. Brooks left the scene that we just watched?
I forgot what that guy was at, the little stoppers, like where it stopped everybody. But we came into contact with him, and then he called the police officer, and then we had contact with the police officer.
Okay. At any point while Mr. Brooks was still present for the scuffle, did you or anybody else in your group call the police?
No.
You need to turn on the state table, please, for preview mode.
I will confirm it's in front of mine and the witnesses monitor, or on our monitor.
All right, Ms. Runkle, I'm showing you on your monitor a photograph that's been marked as State Exhibit number 5. Do you recognize that photograph?
Yes.
Who's in that photograph?
Erica?
Erica Patterson? Is that an accurate representation of how Erica looked the night of November 21st, so after the Waukesha Christmas Parade?
Yes.
I'd move Exhibit 5 into evidence and ask to publish.
Any objection?
Yep, on the grounds of, that is hearsay.
The objection's noted, it's overruled. Exhibit 5 is received, permission to publish is granted.
Were you with Erica Patterson the day before the parade, so November 20th?
Yes.
Did she have a swollen left eye on November 20th?
No.
I want to go back to the issue of police and whether or not you had contact with them. Can you describe in a little bit more detail what exactly happened with law enforcement after the defendant left the scene that we just watched?
I'm not sure where we walked, but like I think we walked straight down to the parade. I'm not sure, but we stopped at these like stoppers where there was this I don't know what he's called. It's not a cop, but he was like a guard, and he ended up we ended up telling him that what happened, that Erica almost got ran over. I had to pull her away from the car, and he ended up calling the cops. He told us, hold on, let me call the cops, and a cop came, and we started talking to him.
Okay, but you don't, or do you remember the name of the officer that you spoke with?
I do not.
Okay. That's all the questions I have for this witness.
All right, Mr. Brooks, do you have any questions for this witness?
I sure do. So, my first question would be, you seem to be unclear about when you met Erica. Would you say it was roughly October or November because you wasn't sure which one?
Roughly in between.
Roughly in between.
Yeah. I know it was before Christmas.
Do you, well, you just said that you had never seen her quote unquote boyfriend or whoever she was referring to as that before the Christmas parade. Is that correct?
That was, the Christmas parade was November, right?
He's asking you if you had seen
Not before, but the Christmas parade was November. I'm just asking, right? Okay, so no.
Did she? Do you want her to restate her answer? She answered. She confirmed your question.
I wanted to be direct.
Okay, no, I have not.
So you just testified that you can identify who was driving the said vehicle as soon as you saw the video played. If you've never seen the driver before that day, how would you even know who it was?
I'll object. That is not a clear question. This is just going to confuse the witness. It's confused me.
Also stated, Mr. Brooks, rephrase the question, please.
Would you play the video again, the first 10 seconds? I'm guessing that it was.
Be Exhibit 3.
Exhibit 3. You want us to? You want the first 10 seconds of exhibit played?
Show the witness the first couple of seconds of the.
All right, it's up.
Now you just said, you just testified.
Hold on, it's playing. You want it to stop now?
Stop.
Okay,
You
Play the
just,
first 13 seconds for the witness.
thank you.
you just testified that as soon as you saw the vehicle come into the camera view, you said, "Oh, there's his car." How would you know whose car it was if you've never seen this person before that day?
Do you
Can
understand the question?
Yeah.
Go ahead and answer.
Because I was told that she was going to meet up with Daryl Brooks.
So you were told this directly from Erica.
Yes.
Did at any time she ever tell you what kind of car he had and what kind of car he would be meeting up with her with, quote unquote?
No.
So how can you identify that it was the said person's car if you had no knowledge of what vehicle this said person would be driving, or who the person even was, or who what the person even looked like? How would you know?
Because I was told it was Daryl Brooks.
And so you were told that it was this name, but you were able to identify the vehicle and the person on the first day that you ever saw them.
Objection.
Is that-
asked and answered.
Let him finish his question.
Again, as soon as the car came into camera view, you immediately said on the record just a few minutes ago, "Oh, there's his car." Who is Who were you referring to?
Daryl Brooks.
And you would be able to know that that was quote unquote Darrell Brooks just by seeing the car come into the view of the camera?
I'll object based on an asked and answered question.
Sustained. Mr. Brooks, are you trying to ask her whether at the moment in time she first saw the SUV, did she know who was driving? That would be a relevant question.
Did you know who was driving the SUV that you saw when you saw it?
Not in court, but when you first saw it on that date.
Yes, because I don't see why Erica would be talking to anybody else and getting yelled at by somebody else.
But did you know at that moment who was driving the car?
Yes.
And how would you know that? You just said that you had no knowledge of the vehicle that whoever Erica was meeting up with would be driving. So how would you know that?
Objection, asked and answered, and argumentative.
Yeah. Her answer previously, Mr. Brooks, was she's basing that on what someone told her, not based on what she saw at that point. That's at least how I took it.
So Erica told you the vehicle and how the vehicle would look?
Do you understand the question?
Say that again.
Mr. Brooks?
Erica, I'm
Restate
sorry,
the
Your Honor.
question. No, that's okay. Restate the question, sir.
So let's back up a little bit. Erica told you that she was meeting up with this Darrell Brooks, correct? That's what you said, right?
Correct.
And did she at any time tell you what vehicle this person would be driving and how the vehicle looked?
She did not.
So the first time you saw the vehicle, did you know who was driving the vehicle?
Yes, when she told me. When she told
What
me.
he's asking you though is, did you know based on personal observation,
Oh,
not
no,
based
not
on what
personal
someone told you?
observation. Wait. So personal observation? Oh, no, never mind. Okay, yeah.
So let's just make sure the record's clear what your answer is.
It's based on what I was told when I met up with her.
So it was told.
That's been established. It's been established what was told. So next question.
No, I was going to a different question. I didn't get to it.
All right, well then ask it, please.
I'm trying to. So you were told after the vehicle drove away and you and Erica were alone? Is that when you were told?
Yes.
So it would be fair to say that before you were told this, after the vehicle drove away, you did not know who was driving the vehicle, correct? Would that be fair to say?
Oh, I had a suspicion it was Daryl.
You had a suspicion or did you know?
Had a suspicion until I
So
asked
you
her.
didn't know.
Objection, argumentative.
Yeah, so we've kind of been a little bit circular here. So the objection is sustained. I think we need to be clear, Mr. Brooks, when you ask your questions about what point in time. It's one thing to talk about when she first sees the vehicle because there's been no contact between her and the vehicle, but it's a different point in time when it's later. So you need to make clear at what point in time you're referring to so that your question is clear.
Got you. You identified the alleged defendant in court. Would that be fair to say?
Yes.
And the alleged defendant that you identified was the same person that you saw driving the vehicle that day.
Yes.
The video also shows that, well, let me back up. Matter of fact, let me ask a different question. You made reference to hanging out with Erica in the park, correct?
Yes.
With maybe one other person
Yeah.
present?
Yes.
Hanging out, what were you guys actually doing?
Drinking?
So, would it be fair to say that because of alcohol being involved, that there may have been a misinterpretation of what you saw? Or
No.
what you thought you saw?
Objection calls for speculation.
The question, the way it's asked, calls for speculation. If you could please rephrase it.
Oh, I'll ask it different. How much were you drinking? Was it a few beers, a bottle,
Half a
something to that
pint.
effect? Half a pint. Do you remember what you were drinking?
Vodka.
Do you remember if Erica was drinking?
She was.
And you said that you separated at one point to go hang with another person. I can't remember the name, but would that be fair to say that you separated from Erica to go hang out with another person?
I did say that.
Was that person also drinking that day?
No.
Did that person overhear any conversation between you and Erica?
No.
Would that be the same person that was saw in the video?
Yes.
So that would be Nick. Is that fair to say?
Yes.
And is it true that you did give a statement about what you saw and heard that day? Would
Yes.
that be fair to say? Would it be fair to say that in this statement that you gave, you never mentioned the person that you saw driving make any threats? Would that be fair to say?
I never mentioned.
Well, I have the statement right here in front of me. Would it be fair to say that the statement that you gave that day, that you do not say in your statement that you heard any threats being made or yelled towards Erica? Would that be fair to say?
Possibly.
So do you remember giving a statement?
I remember giving a statement.
Do you remember what you said in your statement?
I do.
So I'm going to ask you again because I just asked. I have your statement in front of me. You did not mention any threats being yelled or made towards Erica. Would that be fair to say?
I did mention some.
What exactly did you mention?
That you were yelling at her, saying that you were gonna kill her and to get in the car.
And that's in your statement.
Yes.
Would you like me to read your statement to you?
Yes.
You sure?
Yeah, sure.
So I'll object based on the procedure that the defendant is employing at this point.
Sure. Mr. Brooks, there is a procedure. I can have the state bring up her statement, I hope electronically, to show her. It would,
That
and
would
then
be fine, Your Honor.
all right.
Bring it up for her to see.
You'll want to direct her to what part. You can ask her to review it, ask her if that refreshes her recollection, and then you can ask her a question. Or even show her that and ask a direct question about it would be another way.
Okay, this is not it right.
No, they'll get it up. It just takes a moment.
Okay, I'm sorry.
are we sure we can't get the front? Because we tested that twice yesterday and this morning, and it should have worked. We sure we can't get the front table?
We can try.
I have it selected right now and I see a black box, so no.
They have to connect it though. You can stand if you want for a minute. Do you need a water or anything?
No.
Jared, want to stand for a second? Go ahead too. We have a lot of new technology in this courtroom, and it's great when it works. But it's a lot to get used to.
Excuse me, Your Honor, if I may ask you, are we still on the record right now, or we are? Okay.
We are. We're just taking a stretch break, but we're still on the record. Why they?
Okay. I was gonna say something to the bailiff, and I didn't want to be disrespectful by.
Do you want me to mute you for a second so you can?
Oh
say
no,
something?
no, it's fine. It's
Okay.
fine. When will I be allowed to come back into the court so I can see everything?
You have earned your right to come back, sir. I mean, I can bring you back if you want to finish your questioning here.
I do.
All right, we'll take a short break for you to do that. All right, I'll have to excuse the jury for a moment. We'll be in recess as far as the cameras are concerned for that. Then, before we bring out the jury, if we need to talk procedure, or Attorney Witchow, if there was something you wanted to address.
Thank you. I think there may have been some misunderstanding on the nature of this statement in question. This witness provided a statement to a police detective, who then wrote a police report summarizing the statement. So the proper method at this point for the defendant would be to confront her by orally quoting from that, asking if she said or didn't say these things. To show her this statement we're not refreshing her recollection. She didn't write this.
Ah, I see. So I didn't know that, but that certainly makes a lot of sense. Mr. Brooks, did you hear what Attorney Witchow just said about the procedure?
Is it a way to verify that that is in fact procedure? Just to be clear for the record. Can we verify it?
I had referenced earlier that I thought you were trying, we might be showing her the statement to help refresh her recollection, but I don't have any of the statements in front of me, and I wasn't aware that it's the police report that may be referenced is written by someone other than this witness. She wrote a statement apparently, but the police report is a summary of her statement. So
how it that kind of makes it problematic though. You could probably see what I'm getting at, Your Honor, by if it's a summary of what she said.
Do you have the statement do you have a written statement of hers?
Yes, I'm trying to get back to it. You know, I got a lot of stuff coming over here.
I know.
Once he finds the statement, I suggest that Mr. Brooks read directly from the statement the portions that he's asking the witness about and ask her if she did or didn't say those things he's reading.
Does the state have it available to put on the monitor if he's having difficulty finding his copy?
Sure.
Let's do that, please.
What was that? I missed that last part, I'm sorry.
It'll be on the monitor in front of you. Oh, we can, yeah, there you go. If you can't find, this is this.
Oh, there's a little.
Bottom of page 2. Oh, right there. In summary.
Why don't you read that to yourself and see if that helps you formulate a question. You need to scroll down a little bit.
Yeah. That's all I need.
Okay. Do you want any part of this shown to the witness?
Yeah. I want to go to that top part that I read first.
Oh, actually, I think we were talking about he doesn't need to refresh. I don't think it's been established he would need to refresh her recollection yet. She's testified from her memory. So you can use what's in this statement, sir, to formulate questions on cross-examination. And you can use leading questions. So at this point, I don't need to show it to her, but you can ask questions. We'll bring the jury back out and you can continue.
Would this be left up for me to see though? Wow.
We can leave it up.
We can leave it up.
Okay.
Is the part that's up sufficient, or do you need to scroll up? Does the state need to scroll up a little bit for you?
I would only need this part that's on my screen now.
Okay.
And then you whoever's strolling, stroll down a little bit past that to the second part.
How about that? You should be able to see both parts now. It starts with in summary near the top.
Yeah.
And then that's page 2 of 5, and then down below, presumably it says 3 of 5, but I'd like to bring the jury out, so let me know when you're ready.
Okay, I'm ready.
All right, let's have the jury brought back in. Mr. Brooks, you're doing a good job at
I'm
coming up with questions and
attempting.
following the process, and I appreciate you asking to come back over here.
Hot.
All right, thank you, everyone. Please be seated. All right. Mr. Brooks, when you're ready, please continue with your cross-exam.
Okay. I'm gonna give everybody time to settle back in for a few seconds.
Okay.
So, Miss, is it Runkle?
It is.
You stated earlier that when you were hanging out with Erica at the park that you were drinking, right?
I did.
And you also stated that you guys separated and you went to go hang out with someone else.
With Nick, yes.
With Nick. You did state that Nick wasn't drinking, right?
Yes.
So I want to ask, earlier when I asked, I think you were asked by Attorney Whitchild if you heard any yelling or anything being yelled at Erica, or I'll forget how you phrased the question, but did you hear any yelling or anything directed towards you guys? And do you remember what you said?
I heard that you were yelling at Erica, telling her to get in the car, and that you were gonna kill her. That was you were gonna kill her was after the fact that you headed out, but that's probably not what you're asking. The fact of you were yelling at her, telling her to get in the car, was the time when you were around. Oh, I mean, sorry, Brooks was around.
Brooks or you? You said you, and then you said Brooks. But you did state that you had never seen Brooks before November 21st of 2021. Would that be
Right.
fair to say?
Right.
And you also did say that you had only heard of him through Erica, correct?
Right.
At any time, did you ever observe any phone conversations or interactions between Erica and Brooks?
Am I allowed to answer that?
He's just asking you whether you have, not the content of any of those.
I have.
Would it be fair to say that you knew a lot of details about their relationship? Would that be fair to say?
I did.
What specifically did you know before November 21st, 2021?
Mr. Brooks? Sure you want to ask that question? Think about some of the pretrial rulings I've made.
Let me rephrase that.
Okay, good idea.
I'm sorry, I'm new. So, in your statement that I'm looking at right here on the screen, it says, it is Runkle, right?
Yes.
I don't want to mispronounce your name. It says, Runkle further stated that she heard Brooks telling Erica he was going to smash her face in and that he was going to kill her.
Yes.
I didn't.
I'm sorry.
Is that what you heard?
Yes.
So you didn't hear what you just testified to hearing,
No.
or did you hear what I just read to you?
I heard that after you were leaving.
After
Not that what you just read. I heard that after you were leaving.
you do know that this is your statement that I'm reading from, right?
I do.
We've established that, and this is argumentative.
Sustained. Rephrase.
I'm trying to figure out which one did you hear.
Objection. Vague.
Did you hear the I'm going to smash your face in, or did you hear what you previously said?
Well, I heard when you were sitting there arguing with her, I heard that.
Who is the you you're referring to?
Oh, I'm sorry. Brooks said that when he was arguing with Erica.
And you claim that it says right here, but through knowing Patterson, she did know that Brooks was Erica Patterson's boyfriend. Did she ever tell you that Brooks was her boyfriend?
She said she said Brooks was her ex.
I'm a little confused by the statement and then the testimony right now.
Objection. That's not a question.
Sustained. Mr. Brooks, you need to formulate a question for the witness.
Did you ever hear, now this is coming from your statement, Runkle stated that after a short dispute between her, Kirby, I guess that would be referring to Nick.
Yes.
After a short dispute between her, Kirby, and Brooks, she saw Brooks get back into the red SUV and heard him saying something to the effect of, I don't swear, so F you, effing bees, you're dead. Did you at any time hear anything like that?
Yes.
So when you just testified, why did that part of your statement never come up? Why did you never say that?
Because it probably wasn't brought up at that time, but it's in my memory.
So what all exactly did you hear?
I heard what you were
We've
saying.
heard you say at this time? Like, the question's not
What
clear to me.
all-
Like, what time frame? And who are we talking about?
When, because in the video it's clear that
Hold on, go back to your question. I didn't mean for you to not ask it. I just want to make sure I understand specifically who you're asking this witness about statements that were made.
I'm asking about who she said was the individual driving the vehicle.
Well, that's different than what you just asked. So if
Well,
you want to change and
because
go to
you
that,
just
that's
you
fine.
just clarified it a little bit. So what exactly did you hear coming from the individual who was driving the vehicle?
I'm sorry, can we just clarify at what point we're talking about?
Exactly.
At the point that I guess I would refer back to the video at that point that we saw on the video.
So what point of the video? There's lots of points. It was many minutes long.
Roughly, I'm not sure, I think it was
Can you describe what part of the video you want?
the part of the video when that she testified to where she said she had the green gloves and
So
she was
in the
standing
beginning of the video?
no, it was like towards the middle. She was standing in the street and she said she had the green gloves because I think somebody asked her which one was she,
Right.
and she
I
said
remember
the
that.
one with the green gloves.
I remember that.
At that point, did you observe anything being said out of said vehicle? Did you hear anything being yelled or screamed or anything like that at that point?
Well, before I showed up, I heard yelling.
You heard yelling before you showed up.
Yeah, because like before I showed up into the video.
So how far were you down the street that you were able to hear what was being said?
Objection.
Not.
Calls for fact, not in evidence. She didn't say what she heard. She didn't say she could understand what was said.
She can answer the question. I'm going to overrule it. I understand what the state is saying, but I think he's trying to establish where she was at that point in time. So go ahead and answer.
No, okay. I was right where you pulled up the second time.
Are you sure you know what I was asking?
It was not entirely clear to maybe all of us, but I was trying to give you some leeway. So
I knew you understood where I was going with that. Were you at a, let me say it like this, were you at a distance before you came into that video? Like approximately how far away were you from the vehicle and from Erica? Before you heard anything being yelled or screamed, as you said.
I was at a distance.
So would it be fair to say that it would be hard to hear the conversation that was being had?
Not really. Brooks was yelling pretty loud.
So you were able to hear the gist of the conversation from the distance that you were at?
Yes.
Even with a parade going on and a street full of people, you were able to hear from a distance, which you just said you were at a distance, you were able to hear the gist of the conversation.
The parade was nowhere close.
answer the question. Were you able to hear?
Oh, yes, sorry.
You were able to hear, even testifying that you were drinking vodka.
Yes.
What else did you hear?
At what point and by whom?
At the same point, what did you hear from Erica at that point?
I don't remember.
But you remember hearing something from the driver of the vehicle who was inside of the car.
Yep.
But you don't remember what you heard from Erica, who was outside of the car and would be more easier to hear.
Okay, thank you for being specific at that. I
You're
remember
welcome.
Erica sitting there telling me that she wanted to go.
So she was telling you that from you being at a distance.
No, she was right next to me. That was when she was walking towards. She said, "Come on, let's go."
At what point was that? Because you just testified that you were at a distance.
Objection, argumentative. I'm also going to object to the manner in which this defendant is asking this witness these questions. He's intentionally misleading her. He's trying to confuse her.
Mr. Brooks, the purpose of cross-examination is to ask questions that are relevant, test her credibility, other things like that. It gets to be a little confusing, at times maybe a little argumentative. I don't have all the reports in front of me, so I can't say whether it's misleading or not. But ask a direct question. You're able to ask leading questions so that she can answer directly. Be as specific as you can, time, place, circumstances. It's helpful for all.
I mean, the video is very clear that,
But you can't testify right now, right? You can't make an argument about the video. So your opinion about it right now, that's not appropriate.
I wanna,
Keep going. For the record, the objection was sustained.
you made a reference to being, a reference to chesting up with the driver of the vehicle. What was said at that point between you and who you were chesting up with?
Well, I'm not gonna go back to that, but I was sitting there saying that you shouldn't be hitting a woman. No, Brooks should not be hitting a woman, and Brooks was saying that Erica Patterson is not a woman.
Are you sure that's what you heard? At that moment when you were chesting up, in your words?
Yes.
You're sure that's what you heard?
Yes.
What then happened from that point?
Then we started brawling it out. Oh, me and Brooks started brawling it out.
What do you mean by brawling it out?
Threw a couple punches. I threw a punch. Brooks smacked me.
So did you put that in the report that you made, or the summary of the report that you gave to, I think it was Attorney Whitchaw said, a detective?
Objection, there's no evidence this witness prepared a report or a summary.
Sustained.
Did you report that in your report?
It's something that's in my memory, but I hope I did.
Would it be fair to say that if you had just brawled with someone and talked to a detective that you would report it? Would that be fair to say?
Can you say that again?
Would it be fair to say that if you had just had a brawl with someone and you talked to police directly after the brawl that you would report it? Would that be fair to say?
Okay. I know you're asking a question, but
Hold on. You need to ask. You do need to ask.
okay.
You do need to answer his question. It called for a yes or no answer.
Okay, it's not in the report. I specifically said.
Hold on. That's not a question, though.
I'm
Okay,
sorry.
so that's okay. Ask your next question.
Would it be fair to say by the video footage that there was no brawl or punches thrown by either party? Would that be fair to say?
There was.
Can we show the witness the video again?
Are you asking her whether the video shows a brawl?
Would it be fair to say that the video shows a brawl in which you just said that punches were thrown? That'd be fair to say.
Okay, so what's a brawl to you?
You can't.
Oh, I'm sorry.
I know.
Okay,
I think
well,
hold on, Mr. Brooks, are you trying to ask whether are you going to confirm with her that she saw the video, and then on that video, you cannot see a brawl between her and Mr. Brooks? Is that what you're trying to get at?
A version of that, yes, but I was
You
gonna
got to ask the questions,
I
though,
was
to
gonna
get to
say,
that.
can the video be shown to her again?
Ask your questions, sir.
In the video that you saw, would it be fair to say that a brawl was not depicted on that video? Would that be fair to say?
I don't know big words. What's depicted?
Can you see it in the video? Is that what you mean?
Yes.
That's what I mean.
Yes, I could see it.
You could see the brawl?
Yeah, I say it's a brawl. It's just it's just like a push, looks like a push, but it was a smack. And I got up and, yeah.
You got up, so you.
I got up and swung.
You were knocked to the ground.
No,
So where did you get up from?
from being pushed and smacked.
So you fell to the ground.
I didn't fall to the ground.
Sustained. Next question, sir.
So would it be fair to say that in the video it shows you being knocked to the ground?
I was not knocked to the ground. I staggered back.
Would it be? I got kind of thrown off for a second.
You and me both.
I,
People need to make sure their phones and other electronics are not audible.
would it be fair to say that the video does not show you being knocked to the ground at any point? Would that be a fair assessment?
So I'll object to relevance because the witness never testified that she was knocked to the ground. So this is not a question aimed at her credibility.
She just said she got knocked to the ground.
She did not.
She,
She said she got up. I'm sorry. She said she got up, which would constitute being, if you're not knocked to the ground or down,
war
you can't
words
get up.
here, Mr. Brooks.
I'm sorry.
It's okay. No, she was clear. I think she clarified what it meant by getting up, and it might mean something different to you than it does to her. But we need to keep going.
So can I ask what is getting up? What does getting up mean to you?
Stagger back.
So it would be fair to ask you then, does the video show you staggering back?
It does.
Does it show you being, as you called it, smacked?
It does.
Can we show her the video again?
Go ahead. Play the video. You want it to the jury or to her?
To her.
All
I would
right.
ask that we publish it.
I think it's an exhibit, sir, and let's publish it. Okay.
Your Honor, would it be too much to ask if we went straight to that part of the video?
I don't know what part it is. I don't have the timestamp.
I'm guessing this might be it right here.
It's coming up.
Let's just watch, and then we'll ask questions. You'll ask questions when we're done watching.
So we're playing from 3 minutes and 9 seconds on Exhibit 3.
You can stop. That's
All right, what's the time for the stopping of the video, please?
3 minutes and 47 seconds.
All right, your question for her then, based on that?
My question would be, you just viewed the video again. That'd be fair to say.
I did.
At any time in that video, were you in fact smacked and staggered back?
Can I tell the exact time?
If you know, yes, go ahead.
At 3:23.
Can we see 323?
Go ahead. We'll start it a little bit before, so make sure to capture it. You should be able to see the time.
24.
Okay.
So we went from about 319 to 327.
Thank you. Your question regarding the video,
My,
sir?
my question again would be the same question. You just saw it again. In the portion of the video you just saw, would it be fair to say, on your part, your interpretation, that you were in fact smacked and staggered back?
Yes.
Next question.
Were you, are you sure you weren't over exaggerating that?
No.
It looked like a push.
Objection argumentative.
Sustained.
Would you say again what happened directly after that?
Directly after the smack,
Directly after what you say is a smack?
staggered back.
No, directly after that whole incident.
I call it get up, but I came back and swung.
Would it be fair to say that the video doesn't show any of that you just said? Would that be fair?
It shows it somewhere.
So would it be fair that you're saying your interpretation of what you just saw would constitute a brawl, as you say, or brawling it out, as you say?
Hold on, Mr. Brooks. I've given you a lot of leeway on this topic. What's the relevance of all of this at this point? I think you made your point about what happened and what didn't, and what's in the video and what's not, and the jury can ultimately decide that. You can argue it later on to the jury.
I'm sorry, I thought the state
Where are we going?
was supposed to object to that. If they saw an objection, I'm a little confused about that.
I need the questioning to kind of circle back to what's relevant for the trial.
Well, I thought it was relevant because of what the video is actually depicting.
And that video is going to speak for itself. It's been an exhibit.
Yes, it
And
does.
so you've asked a lot of questions about it. So let's move on. Under 906.11, that's my authority. I'm telling you to move forward. Next line of
Did you
questioning.
hear anything after the, as you say, brawling out? Did you hear anything coming from the vehicle? Was anything said to you directly coming from the vehicle at that point?
Do you understand the question?
Would it be after you leave? Oh wait, Brooks leaves? Or when
I was
Brooks gets
clearing
in?
what I just asked after the brawling it out.
But you asked directed at her, and then you said anything from the vehicle. So that's a compound question. So you need to be specific.
Did you hear anything after the brawling it out, as you say? Did you hear anything directed towards you?
Directed towards me? No.
Did you hear anything directed towards Nick?
I remember something being said.
Do you recall what was said?
I do not.
Did you hear anything directed towards Erica?
Yes.
What did you hear directed towards Erica?
At what time?
Right after the brawling it out, as you say. Did you hear anything directed specifically towards Erica?
Not till he left. No, not till Brooks left.
Would you say that again?
Not till Brooks left.
So, did you or did you not hear anything directed towards Erica after the brawling it out, as you say?
Oh, okay, no.
So can we pull that statement up again?
Go ahead. The state would do that once again. Just to the preview.
I'm reading directly from the statement, where it says,
Mr. Brooks, it may or may not be a statement, so you need to be accurate. I know you're referring to
the
a police
summary,
report.
the summary of the statement. I'm reading directly from the summary of the statement, where it says, Runkle stated that after a short dispute between her, Kirby, and Brooks, she saw Brooks get back into the red SUV and heard him saying something to the effect of "F you effing bees, you're dead," as he was leaving.
So I'll object on 2 grounds. 1, asked and answered, and 2, this could confuse the witness because it's not, she used the F and the B.
Sustained.
It was something on the back end of that I didn't get to.
I'm not sure what you mean by that, sir, but
It
you've already asked that question before, so the objection is sustained.
I actually don't recall asking a question directly to that part of the summary.
I do. You read through that previously.
Do you remember what the question was, so that I don't re-ask the same question?
Mr. Brooks, move on.
Did you ever hear something to the effect of "F you effing bees, you're dead"?
I did.
At what point did you hear that?
While Brooks was leaving.
So that would it be fair to say that you heard that after the brawling
Yes.
it out?
You shook your head. Can you say
Yes.
Thank you.
That's a little confusing. So
Mr. Brooks, that's not a question. You're attempting
I'm
to
about
testify.
to ask a question.
You
If I
can't
can
do
get
that.
to it,
Ask your question. But you also can't mischaracterize the testimony or the evidence up to this point.
what do you mean?
In your questions, you can't mischaracterize prior testimony or evidence. You have to be accurate. So
I'm trying to be, but it's
what's your next question, sir?
kind of hard. Just a quick second.
Right, unless you have a different topic.
It
Anything-
is.
hold
It
on.
is.
Anything related to this, what's in the summary, the questions regarding what she heard or didn't hear around this time, we've gone through that, you've gone through it. Under 906.11, you need to move on and ask a new line of questions.
I was trying to, if I can get to it.
Go ahead.
This part of the summary that I'm looking at now says Runkle stated that she did see pictures of Brooks following the Christmas parade incident via social media, and Runkle confirmed that was Brooks was I don't know, it looks kind of, I don't know if that's a mark on my screen that's going through. Okay, I couldn't read it.
I'll object. I don't think there's a question there.
Right.
I didn't get to it yet.
Well, then I'll object to the ongoing commentary with lack of any questioning.
And I'll sustain that objection.
Oh, I do have a question. You said that you had known Erica roughly since you were rooming up at the women's shelter. Would that be fair to say?
Yes.
Do you have any idea why she would refer to you as Corey Gray?
Because I go by that.
So how well or how close would you say you guys were?
Close.
Close, like hung out all the time, every day?
Yes. Hung out every day. Sorry.
And do you know of any time before November the 21st of 2021? Do you know of any time before that Erica mentioned to you anything about the relationship that she had with Brooks outside of what you learned that day?
Can you say that again?
At any time before November 21st of 2021, did Erica ever confide any information to you before that day?
She did.
What was the nature of the information?
It's not allowed to be brought up.
I think she's referring to a pretrial ruling that she's aware of.
Yep.
So, you want to rethink asking that question, sir? Otherwise, I'm going to allow her to answer it.
What pretrial?
I'm not going to state.
No,
That
I'm
right
not.
now.
Are we both privy to the same pretrial procedure?
There was a pretrial ruling about.
Do you want her to answer that question, or do you want to move on?
I want to move on.
All right, I'll strike that question from the record. The jury will disregard the question that was asked.
So I would want to ask, was there any, during the brawling out point, was there any interaction between the driver of the vehicle and Nick?
There was.
Do you remember what the nature of that interaction or exchange was between those two?
I don't know. I just remember jumping in front.
Do you recall any threats being made towards Nick or from Nick towards the driver of the vehicle?
Oh, I do.
Relevance.
Overruled, she may answer.
I do.
Do you remember what was said specifically?
Not specifically, but I remember Brooks getting mad because Nick was coming to Erica's rescue. Right along with Corey. Me.
Do you recall any knife being involved in any of that situation
No
during
knife.
that exchange whatsoever?
No knife.
Were you aware that that was why police was responding to that incident?
I did not.
Did you at any time have a knife during that incident?
I did not.
Do you know if Nick had a knife during that incident?
He did not.
Do you know if Erica had a knife Do you know if Erica had a knife during that incident?
She did not.
As far as your memory, do you recall reporting that a knife was involved in that incident?
I do not.
Do you recall if Nick reported a knife being involved in that incident?
It's possible.
Do you recall Erica reporting that a knife was involved in that incident?
I do not.
You testified to drinking a half pint of vodka that day. Was that the only thing you had to drink that day?
Yes.
Would it be fair to say that you were tipsy?
Yes.
Would it be fair to say that you may even have been intoxicated?
No.
For any reason that day, acknowledging that you were drinking, would that have impaired your thinking of the situation in any way?
No.
So would it be fair to say that you were of clear and sober mind during that whole incident after drinking a half pint of vodka?
Yes.
So there, to the best of your memory, there wouldn't be any reason why you may have left something out or maybe not been clear about anything that happened during that specific incident.
Possibly left some things out.
Do you remember what they might have been?
No.
Do you know the plaintiff?
Objection for previous reasons.
Sustained.
Have you ever seen the plaintiff?
Objection.
Sustained.
Have you ever had any interaction with the plaintiff?
Objection.
Sustained.
No further questions, Your Honor.
Thank you. Any redirect?
Very, very briefly, Your Honor.
Go ahead.
Ms. Runkle, you met with Detective David Van Els to provide a statement on November 22nd of 2021. Do you remember that?
Yes.
That's accurate?
Yes.
Okay. You remember telling Detective Van Els, when he was asking you about this incident, that when you arrived, you heard Daryl Brooks telling Erica Patterson that he was going to, quote, smash her face in and that he was going to kill her, end quote.
Yes.
Okay. Do you remember telling Detective Van Els that as you saw Brooks get back into the red SUV, you heard him say something to the effect of, quote, fuck you, fucking bitches, you're dead, end quote.
I do.
Okay. During your cross-examination, you repeatedly referred to a person as Brooks. The person depicted in the video, Exhibit 3, the person that you chested up to, is that person in the courtroom?
He is.
Can you point him out for us and just very clearly tell us where he's sitting, what he's wearing?
You want me to point?
Yes, please.
All right, he's right there and he's wearing orange.
I'd ask the record to reflect that the witness has identified the defendant.
It will.
And I have no further questions. Thank you.
Thank you. Thank you, ma'am. You may step down. All right, ladies and gentlemen of the jury, this will be an excellent stopping point for us this evening. Thank you for your patience this evening. I do need to go through one instruction with you. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, application, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has any reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are excused. I will provide information to Pete and Mike shortly as to what time we will start back up tomorrow. Thank you. All rise for the jurors. Mr. Brooks, I want to commend you for a couple of things. Number one, asking to come back into the courtroom. I really appreciate that. I appreciate you being here. I think it runs much smoother when you are here, assuming you follow all the rules, which you have done a very good job at this afternoon. I also want to commend you on cooperating with the process even before you were brought over here. You were respectful. But you also made appropriate objections. You asked questions on cross-examination. Despite not wanting to unmask at first, you did do that, and I appreciate that. You asked some cogent, relevant questions, some of which went directly to the credibility of the witness. I would add, you might not always artfully ask the questions, but I think you're making some solid points. I would encourage you to keep prepping, to have questions written out based on the materials that you have. I really appreciate that you came back over and that you've been following the rules. I also want to encourage you, sir, to, if you choose, to wear your suit or other street clothes. It is your choice. I will let you make that choice. And but I encourage you to consider that. I don't think there's anything we need to address other than perhaps timing. We went a little bit late here tonight, so I think I'm going to have the jurors report. I tell them we're going to bring them into the courtroom at 9. That usually means a little bit earlier with their protocol. We'll still start at 8:30 to address any housekeeping items at that point in time. Is there anything the state wants to address right now, or any record you want to make?
No, Your Honor, thank you.
Mr. Brooks, anything you want to address right now, or any record you want to make?
No, just thank you for giving me a chance to come back in, and I appreciate what you said.
It works well when you're here, sir. I hope we
Let me just
continue
say
this.
something very, very quick. I was waiting for my COVID results to come back before I feel comfortable getting back dressed up. So I kind of just prefer to just stay in the orange right now.
All right, that's your choice.
They said I should be having the results hopefully by the time I get back. I might know something. If not, I'll know something tomorrow morning. So that would be a big influence on.
Okay, fair enough. The other thing is I had not been utilizing an all rise. Sometimes you stand, sometimes you don't. It is something I'd like to go back to, especially as it relates to the jurors. It's out of respect for them. So I will be doing an all rise for when the jurors enter and exit. And just given some of our logistics, I'm not looking for an all rise for when I enter at all. So my bailiffs are aware of that. But that's it for today. Good night, everyone. We'll see everyone at 8:30 tomorrow morning.